Your Lordship, the
Writ
matter,
appeal, my lord.
Kindly, my lord. Matter it was posted specifically on 24/2. It was adjourned to 17/4. 17/4, I filed an application for preponement to 11th, my lord, last my kindly.
It is kept on 17/4.
Yes.
So what is the matter?
Contempt matter, my lord, all of his juniors have been promoted.
This is for preponement. I'll post it on Monday.
Your Lordship, it's a PIL that's
Writ appeal, fresh writ appeal, my lord, challenging the learned single judge's order, permitting the persons who are overage to have surrogacy under the Surrogacy Regulation Act, my lords, without deciding the validity of the provisions which they had challenged.
We checked.
Surrogacy Regulation Act 2021, my lords. The aged persons, more than 57 years, has been permitted to undergo surrogacy, and also subsequently same order is being followed in other cases, my lords. It is affecting the very provision of law itself, and it is under challenge before the Supreme Court also, my lords. Fresh writ appeal filed by the Union of India. Any date may be
17.
7th.
17.
Fresh matter. It is a fresh matter. The matter arises under the Environmental Act, where the Environmental Act, my lord, the factory not violated the conditions of issued by the board of the pollution board, my lord. For the last 6 months, waste of water coming into my farmhouse. Hence, I am unable to cultivate my land, and there is scarcity of drinking water. Therefore, any date next week, my lord.
25th of March.
Much of.
My lord, one fresh matter for
Item number 52, Your Lordship. I'm filing memo for withdrawal.
62.
52, Your Lordship.
50.
52.
Withdrawing.
Yes, Your Lordship. As the accused prepared appeal before the Apex Court.
Contempt petition 110024, Mohammed Tahir seeks permission to withdraw the contempt petition by filing memo dated 5/3/24/25, in which it is stated that since the accused has prepared special leave petition before the Honorable Supreme Court challenging the order passed in MFA number 263/23, the present contempt petition is not required to be prosecuted, and as it has become infectious. In view of the memo and the request made, the permission is granted. Full stop. The contempt petition is dismissed as withdrawn.
my lord, one fresh appeal, my lord, of challenging the order of the learned single judge. My lord, the order of punishment of compulsory retirement, my lord, is reduced to 3 increments, my lord, in view of a misconduct followed with charge sheet and discipline. My lord, the contempt is filed, my lord, on 11th, my lord, the contempt is posted, my lord, therefore any day before.
Tell that the contempt, you can tell that appeal is filed.
But any day may be fixed, my lord.
Let it through memo. It will come within one week. Yes, ma'am.
concerns a PIL that has been filed in 2021. I've also filed an IA for early hearing. It may be taken up because it was listed for 2nd January, and because it was declared a holiday, it didn't come up. And I'm filing a memo for
What
it.
is the PIL?
It concerns the impact of railway lines in the Western Ghats on the wildlife. And it also, it's
Impact of?
the railways in the Western Ghats and their impact on the wildlife there.
24th March.
Much obliged.
My lord, serial number 81 and 82.
Yes, Mr.
My lord, serial number 86, my lord.
Hmm.
I appear for respondent number 3 in that case, my lord. I have no objections to condemn the delay. IA number 2 of 54. I have no objections with respect to application.
With consent of the parties, delay of 2 days in filing the learned advocate, Mr.
Respondent number 3.
Mr. What's your name? So and so appears person 3 and states that there is no objection to condone the delay of 2 days. So in that view, IA number 2 of 24 is allowed by condoning delay of 2 days.
My lord, serial number 16, my lord.
But then all, he is appearing, any other respondents are there? Any other respondents are there?
Yes, there are some response.
So then
I
how can
appear
you-
for respondent number 3 only, my lord.
Then there is no point in mentioning, yes.
My lord, serial number 16, the counsel on, counsel Preeti K is not well, my lord. Lord, who appears for the complainant, she is unwell today, my lord. 3 days time may be given.
Lord, I am for the respondent in this case. Is the commissioner?
Serial number?
Serial number 16, my lord, page number 2.
Oh, 16.
My lord, counsel is not well, my lord. The counsel appearing for the complainant, she is not well. My lord, this is the case where commissioner was appointed. He's filed a signed document before this honorable court. When the last side of hearing, my lord suggested that, in the left side of hearing, if it is filed, we close it. So it doesn't matter whether, we are not making representations as much, as such, so it kindly be heard.
Counsel is not well.
Next week, Monday, Tuesday, any date.
17.
70.
My lord, serial number 81 and 82 kindly may be posted to 10-3 as it is a connecting matter. Serial number 81 and 82 kindly may be posted to 10-3. It's a connecting matter, my lord.
10. Both. Connected matter is coming up on 10th.
10-3.
81 and 82. Stand out to.
My lord, there are 5 connected matter listed for tomorrow. These are 2 other matters. It may be taken up tomorrow itself. Contempt matter, my lord.
No, we'll take up whichever matter to listed today.
I'm giving memo for posting for tomorrow, my lord. There are 5 connected matters listed tomorrow. These are other matters that has to be posted.
They are posted tomorrow.
Yes, my lord. Connected matter.
Yes, madam.
Serial number 28. Kindly
28.
grant 1 week time. ma'am.
28.
Yes, madam. Writ
So-
appeal and contempt matter. ma'am.
What do you want? Time?
Yes, madam, 1 week.
Second April.
Your lordship, with regard to serial number 28, 28.1 is contempt petition. We filed withdrawal.
Withdrawing.
And yeah, the contempt
So
petitioner in the.
28.1, learned advocate Ms. So and so,
Which one?
praise that she may be permitted to, praise upon instruction that she may be permitted to withdraw the present contempt petition. Permission is granted, the contempt petition is dismissed as withdrawn. You file some memo,
Yeah, it has been filed.
full stop. State requested by inviting attention to the memo dated so and so file. Seeking withdrawal. Yes,
If your lordships kindly, one surface matter, my lord. My commercial property is with the bank. Commercial property is in the possession of the bank. The matter stands posted to 27-3, but the other bench, when it was listed before the other bench, it is posted to the 27-3. I'm requesting the matter to be taken up next week, my lord. And for the borrower, commercial property is with the
which matter is posted on 27 before another bench?
27-3 it is posted. my lord. This
Which
matter.
is the other matter?
Both the matters, my contempt matter and the writ appeal by the bank. My lords may have it next week,
This is what contempt matter.
both matters, writ appeal and the.
No, you are saying before different bench it is posted
No, earlier,
earlier,
last week.
25th of March.
Next
Yes.
week.
My lords, may I mention serial number 29, my lords,
Hmm.
appearing for respondents. Senior has some inconvenience, my lords. Senior has some inconvenience.
Petitioner
Request
is
for
informed.
short. Please, my lords.
Petitioner is
Appellants have informed. my lords.
7th of April, as requested by both the sides.
Obliged.
Serial number 57, my lord.
57.
Press for time, my lord.
What do you want?
Inform already other side also, my lord. File my reply next date of hearing, my lord.
2nd April, as requested by learned and respondent, with consent of the petitioner. Yes.
Any mention through VC, sir? Contempt matters, seal number 1. Ashwini Kumar H.
For the complainant in this case, my lord, regarding the contempt petition against the accused is, my lord, regarding the disobedience in the complying the learned single judge order, my lord.
Where is that order?
Order dated, my lord, 23rd February 2023. Regarding the regularization of unauthorized occupation, my lord, within 3 months.
Inquiry is
direct-
held or not?
Yes, my lord.
Inquiry was to be held. Some
Yes,
inquiry.
inquiry was not done after giving the representation also. Notice is not issued.
That we know, but when you are standing with what we are appearing, notice written on 8th of April.
Please, ma'am, grateful.
Seal number 2 to Vijay Kumar.
Appearing for complainant, my lord. The respondent accused have not complied the order dated 8 January 2024.
Notice written on 9th of April.
Seal number 3
Prabhu Gowda Tumbigi. Seal number 3. Seal number 4. Adi Narayanappa.
It's right of direction, the
Interim
single
order.
court order, which is produced at Tanif.
It's an interim order.
In page 12, there is a specific direction from the this court. In spite of it, they have changed the revenue record.
Order which is brought under the contempt jurisdiction of this court is order dated. What is the date? 27 November 2024, which is admittedly an interim order. Full stop. The proceedings of the main writ petition are pending. Learned single judge has only issued notice and directed the respondent number 1, 2, 3 to maintain status quo in respect of the revenue increase for the land in question till the next date of hearing. Not only that, any of the rights of the parties are not finally crystallized, the status quo is granted up to next date to be subject to further consideration by law and single judge. In the above circumstances, the parties will have their liberty to agitate before law and single judge on all the aspects, including the alleged breach of status quo. Also, the court is not very well inclined to invoke the jurisdiction under the Contempt of Court 6, 1971. For the above reason, in respect of the order which is interim, without going into the merits, the contempt petition is not entertained and stand disposed.
Number 5 to Babu Rao.
But there is an order regarding pensionary benefits to clear the 3 months, April 24, my lord, and subsequently 2 representations.
Returnable on 3rd April.
Obliged.
Number 6 to Subramania Bhatt.
Here for the complainant, your lordship. The order is at Annexure B passed by the learned single judge. It is passed on 22nd February 2023, your lordship. The operative portion is at page 27, wherein learned single judge directed the respondent to pay all the benefits to the petitioner complainant
Notice
in 3
returnable
weeks.
on 7th April.
Great.
Number 7,
Paying for the petitioner,
Karthik.
complainant. Refixing the Hyderabad quota with effect from the date. The Honorable Court has recorded the submission of the government. Till today, even after 1 year, they are not refixed with effect from 21/4/2020.
Time is
We have been considered under general non-HK category, though he belongs to HK. Is the undertaking of the government.
So it is beyond 1 year.
They say that they will do it. Even after 1 year, we are given the representation.
Your right to file contempt extinguished, even if at all there is a contempt.
and there is no time stipulation also.
Time is not stipulated. That is the reason.
So time will start from the date of the order. Following is the order dated 1st August 23, passed by the coordinate bench, which is alleged to have been breached by filing this contempt. So quote the order. Section 20 of the Contempt of Court Act reads as under paragraph. After quoting, in view of the above provision, the cause of action to file the contempt proceedings for the petitioner commenced from the date of the order itself. at the expiry of 1 year. The cause of the contempt was not maintainable.
Shall I make one submission, Lordship?
In the above,
I may be approached to the tribunal so that I can seek for a direction,
withdraw them.
because if this will not come in the way, then the very undertaking will be.
Tell if I last. Is not maintainable in the aforesaid view. Full stop. It is therefore not entertained. At this stage, learned so and so submitted that the petitioner may be permitted to take a recourse. Full stop. Any recourse available in law, in accordance with law, is permitted for the petition, will be permissible petitioner to seek the redressal. However, this court does not express any opinion in that regard. Does not express any opinion in the merits in that regard.
Still number 8, to Basraj Patel.
Client. This point has not given the promotion by opening the sealed
Promotion
cover.
not given. Where is the direction?
Page number 15, my lord.
That is correct. but
Last
where is
but one paragraph. In the above circumstances,
that?
this petition is allowed in part impugned order of the KT, although in the subsection maintained is modified to effect that the jurisdiction respondent shall open the sealed cover forthwith and process of the contents thereof.
So thereafter, what did you do after this? Anything, any letter, notice, communication address?
No.
Straightway to the court.
Yes.
Contempt is alleged in respect to the following directions found in the order dated 2/7/24 passed by the dated 16 December 24 passed by the coordinate bench, which are with respect to consideration of the case of the petition for his promotion. So this quote, page 15. A reading of the aforesaid direction would show that no time limit is fixed for carrying out the direction. In the circumstances, it is not possible to conclude at this stage that any of the respondents have committed contempt, or much less willful contempt. Therefore, the contempt petition under Contempt of Courts Act 1971 is not entertainable. First of power, in order to ensure that the orders of the court, orders and directions of the court do not go uncomplied with, it is directed that the directions contained in the aforesaid order of learned single judge will be acted upon by the respondents concerned within a period of 8 weeks from today. With such observations, the contempt petition is disposed of as not entertained.
Still number 9.
The peer for the
Please, Shankar.
complainant. That's the order of against which contempt is preferred is at page number 25. Starts. The order is dated 28th August. Direction is at page 55. Order had to be complied by October of 2024. May I make one request?
Notice written ever.
Between the same parties, there was another order passed by the very same learned single judge, against which writ appeal was filed by the government. That writ appeal, came to be disposed of by your lordship's order dated 23rd of January. Now, insofar as the remaining matters, again, they have refused to comply. My house is, now being put to auction because of non-payment. My only request is, can I request for a shorter date? Because your lordships have decided between the same parties.
25th March.
Great.
But 10 to
9 to 13,
Same.
same, and serial number 84.
9 to 13, same. 84 is also same. 84 is all fresh. matter.
84, my lords, fresh matter. The objection is, my lords, BBMP, there was no BBMP made as a party. It was to the government. Let's keeping open the office objection, your lordships can issue.
So notice.
Great.
Office shall be completed for the next day,
Very-
within 2 weeks.
Please,
Same order, then add the line.
great.
Seal number 14, Station Basuraj.
Appearing on behalf of the complainant, my lord, the order was passed by this honorable court on 26th June. And the order has not been complied. The 4 weeks time was given to the accused to comply with the order. It is at para 5 and 6 of the order. The time given expired in the month of July. However, the representation was made by the complainant to the accused on 16th November.
4th April, written. Notice, 4th April.
Seal number 15, Mr.
Madam.
Chandrasekhar.
But single judge order was confirmed by this honorable court on 18 December 2024, my lord, by giving another 4 weeks time in the contempt that was filed by us. This is the third round of contempt petition I am filing, my lord. It's not been complied with. It's more than 6 years.
Notice, 4th April,
On short date, I request my lord, since
not post. Lot of matters are coming, yes.
16.
date may be fixed.
4th April.
4th of July. 16 is adjourned. Seal number 17, Mr. Arjun Rao.
Matter, my lord.
Petitioner, your lordship had directed the government advocate to get instructions on this, my lord. This is a case where the entire advance amount had to be repaid, 2 crores 20 lakhs.
This with regard to the deposited amount paid during the bid 2007, my lords. Now, it's in the process, my lords. I request for 3 weeks adjourn, my lords, because presently the ongoing budget session is going on, my lords. Now the government has processed to the taken an approval from the finance department, my lords, yet to get an approval, my lords. I pray for 3 weeks time, my lords. In the process, my lords, this amount will be
You file affidavit of the competent officer.
my lords, in this regard, my lord, the technical difficulty is that, my lords, now presently the budget session is going on, my lords, and
We
we
are
are
not concerned with the budget session, Mr. File affidavit.
earlier,
We are
occasion,
not concerned with your budget session. You have to comply with the order. of
we
the
will
court.
comply, my
File
lord.
affidavit. Within what time you are going to? We don't entertain the irrelevant submissions.
No, my 2 weeks, my lords, we will
No,
comply.
no, budget session, you spare your officer to file. They can't file affidavit with the High Court.
I'm praying for 2
No,
weeks
sir.
time, 2 weeks.
Not entertaining at all.
We'll file affidavit, my lords.
File it when will.
2 weeks, 2 weeks I'm praying for time, my lord.
We are wary of your irrelevant submissions,
2 weeks, my lord.
often made time and again in many matters.
No, my lord. My submission was, I file affidavit for 2 weeks, my lords.
Now you file affidavit. Respondent. Who will be pleasing?
The
Your
Principal
submission
Secretary,
irritates the court.
No, I file affidavit, my lords. I'm praying for 2 weeks time to file affidavit, my lord.
We'll grant time, but don't say that dear, this election is there, and budget is there. We are not concerned with your budget.
I'm sorry, my lords.
We are court of law, High Court. You must obey the High Court's
Please.
order.
Please, my lord, oblige.
Yes.
For 2 weeks.
Don't follow such instructions of your officer. We
Sorry.
are not concerned with your affairs. We are concerned with our affairs.
Please.
In the compliance with the direction. When you are going to pay 2 crores 20 lakhs, tell us
Praying
by
for
filing affidavit.
By-
File affidavit before, or before,
2
or not
weeks.
before.
2
No,
weeks.
on over 12, you file the affidavit. Affidavit shall be filed by the respondent. On or before 12th, as to within which time the order will be complied with.
Please.
Other will be very strict.
Please.
You are taking very lightly, Mr. Counsel.
I'm sorry, my lords. That was not my intention, my lords. It's in the
Intention or
process,
no
my
intention,
lords.
but you are taking very lightly and don't know how to deal with the contempt matters and how to make submissions before the High Court. Yes.
The green bench matters, seal number 18, the Ganpati Bhatt.
Yes,
Okay,
Mr.
pass
Okay.
out. Pass out, my lord. Senior is held up in another court.
It is refused. They declined the prayer for grant of lease
Yes, my lord. Application filed, my lord, application is.
Where is the application? It is rejected. Your application is rejected.
My lord, kindly pass over, my lord. Kindly pass over, my lord.
My lord, application is filed seeking for grant of quarry lease, my lord. Thereafter, there has been no demand, there has been no refusal. And they are seeking for a writ of mandamus.
You are not appearing. You are not appearing.
No, my lord.
Who appears?
Senior is appeared.
Pass.
Serial number 19, Avinash Goda.
For the petitioner's counsel, Annexure A is the order, my lords, passed by the senior geologist, rejecting issuing an endorsements. Your lordships would get the endorsement at page 22. Now, the second para therein, my lord, is where there is an error. Under the then existing rules, my lords, if the NOC is not received within 90 days, it is deemed recommendation for grant of a lease. Now, the senior geologist says he had written a letter, but there is no report, and he says they have sent only 528 files, excluding my file, which could not have been done, because the rules save my application.
What is wrong in this?
My lords, if your lordship sees,
Paragraph,
my lords,
middle paragraph on page 23.
yes, my lords. There is no provision. That's exactly what is wrong. Under the rules, my lords, KMMC rules 2023, it's been amended, my lords, and it provides saving all eligible applications. In fact, at page 22, the last second para, he says 528 files have been sent, applications have been sent to the government for processing.
For what?
Processing of the application, because processing. But he says there is no information about your quarrying lease application. That he admits that my application is there, but he does not send my application to the government, and then says we can't consider your application. That's the error which they have committed. The first para at page 22, he says my application, they have sought for NOC from the revenue department.
And application doesn't appear to be reached there.
They should have sent it along. They have kept it in their office.
My lord, may I seek instructions? It's coming up for the first time today, my lord.
So notice to the respondents, from having heard learned senior advocate Manindra for the petitioner, there shall be notice to the respondents returnable on 25th of March, full stop on the returnable date, in particular, on returnable date, learned adjacent government notice, Srimati Nilofer Akbar, who accepts the notice, shall, in particular, take instructions whether the application for license of the quarrying lease, the petitioner is filed by the petitioner, and whether it is liable to be considered along with the 528 applications stated to have been sent for processing them.
Very well.
Obliged.
This is the only thing beyond which will not go.
That's the only, ultimately, my lords, that's the what has to be considered. Because
There is no reason if it is there, then not sending.
my lords, that's a mistake which he has committed. The officer has committed.
Probably the law involved in your application is not subjected to.
My lords, because what he says is NOC is not obtained, but under the then rules, within 90 days, if the report does not come, that's the only thing.
Let us see.
Please.
Serial number 20, writ appeal matters.
So delay of 44 days, who appears?
40.
Notice returnable on April 16. 21
Number
also,
21.
same order,
Please.
notice returnable.
Great.
22 also same order,
22.
same order.
It's 22 minutes.
You are appearing in 20,
And for the respondent and here in the complainant also in CCC 3.
so all are appearing.
Please.
I have not received any copy from the appellant.
Notice is
yet to be ordered, my lords. I'll serve the copy today itself.
Notice written on the same order.
Please. Grateful.
But 20
Learned advocate for the appellant shall serve copy of the delay conversion application and the delay and the writ appeal to the counsels appearing for the other side,
Please, brief.
who accepts the notice for the respective respondents. Yes.
December 23. Please. And the
What is it?
Honorable single bench, page number 16, my lord, dismiss the petition. It's a no confidence motion. And on the ground of Rule 3(2), my lord, then 15 days clear notice has to be given. That is not been compliant. And moreover, the petitioner is the SC/ST candidate of the president. He is given the resignation under the threat and force. That the single bench order has not been referred for investigation or anything against the, as well as this against this petitioner. And number 3, my lord, see the representation given by the members. It's a page number 49, my lord. Here is the, as per section 49, there is only member has to give the representation to the assistant commissioner, but there is an attestation by the PDO that could not be done. So under these circumstances, the Honorable Dharwad bench and Gulbarga bench, I produced a reference document wherein the representation of the members. So the PDO has attested, he could not do so.
Any judgment on this day that 15 days have to be counted from the date of notice or from the date of receipt of the notice?
Clear, 15 days clear notice to be given is there.
Karnataka Panchayat motion.
Please.
So it was given on which date?
24, actually 24/12 it was
24/12.
served.
So it was served on 24, but date of notice was what? 19.
Please.
You notice on 19/12/20.
But 24 was served, your lord.
Special meeting was called on 7. So
7 months.
That's the point, whether it is correct for proposition or not.
Learned single, if lordship look at paragraph 6, my lord, in view of the interim order granted by the learned single judge, the learned single judge says that paragraph 6, my lord, since the meeting which was convened on 7/1/2025 has been adjourned because of interim order granted in this writ petition, the assistant commissioner is directed to ensure that the special meeting is convened on 10/2/2025 at 11 a.m. So therefore, my lord, a date has been fixed extending the period, my lord, in any case. And para 7, my lord, since petitioner and all other members who have moved the motion are present, no fresh notice is necessary for them.
Your lordship.
And what is the interim order that was granted?
No, the interim order of stay was granted, my lord.
No, stay means, see, normally the interim order granted is we permit the meeting to go ahead, not to announce the outcome of the meeting.
My lord,
But
this
here,
is
what was the interim order
stay of
granted?
the proceedings, my lord. That is what paragraph 6 says, my lord.
Stay of the proceedings
Adjourned,
system.
my lord. Case was adjourned because convened on 7/1/2025 has been adjourned because of the interim order granted. That was adjourned, my lord, basically. Thereafter, the court fixes the date.
So nothing happened on
Nothing happened, my
that
lord.
particular day, is it?
Nothing has happened. Therefore, my lord, date has been fixed by the honorable single judge, my lord, on 10/2/2025, stating that all the members who had moved the motion were present before the court. Therefore, a date has been fixed and time was fixed, my lord.
And my lord.
Their limited grievance was that the 15 days clear notice was not granted. In any case, my lord, that has been stayed and date has been fixed, a subsequent date has been fixed to enable them to participate. Para 6 says, my lord, meeting scheduled on 7/1/25 is adjourned for the reason that there was an interim order in the writ petition. Let me proceed on that.
There are judgments. What does it? This praise means not less than 15 clear days. So we'll
10 days of clear notice. In the same similar circumstances, my lord.
So you could have resorted to proviso. Even now you can.
Can do that, my
You
lord.
did not do anything.
No, my lord, nothing, I will have to secure instruction what happened on 10/2/25, my lord. That is the date fixed by the learned single judge.
Notice returnable on.
Please.
My lord, today is the election of that state is it. Today because on basis of no confidence motion, today the date is fixed for, your lordship, the, election of the president. Today date they have fixed, and till they file the objection, at least they did.
Will issue only notice. If it is.
My
breach
lord,
of-
similar circumstances, my lord, in writ petition 4557 of 25, by the same single judge, he is referred to before this division bench also. That is been referred. Actually, I have produced in another case, the same circumstances, 15 days clear notice, the trial court could not be decided on the issue.
Why you are moving the court at the last moment?
My lord,
And there is an election today.
and your lordship.
It is the petitioner is
This the-
Gangamma.
this the-
Petitioner is Gangamma.
Gangama is the before the same bench.
It's Nag Prasanna's order.
No, not before the same trial court which passed judgment. In this issue, my lord, 15 clear days notice is the finally opinion is given referred to the before division bench of this honorable court. The trial court is not decided on this writ petition by the same single bench on the point of 15 clear days notice. The court could not be decided in this point, and it is referred to the before the your lordship the under this petition. That is still it's pending. And moreover, this petitioner being is a SC/ST candidate, he is given the resignation under the threat. So I produced the annexures, but the trial court,
The learned advocate, Mr. So-and-so petitioner and learned additional government of the KFRs for the respondents upon service of the copy of the appeal in advance. The issue required to be addressed in this appeal or in the context of the order passed by impugned order passed by learned single judge is to dismissing the appeal is to dismissing the petition is to whether the period of 15 clear days notice contemplated in Rule 3/2 of the Karnataka Panchayat Raj Integrate motion of no confidence against Adhyaksha and Upadhyaksha of Gram Panchayat bracket over Rules 1994 should be reckoned from the date of issuance of notice or from the date when the notice is received by the notice or from the date of service of the notice. Learned advocate for the petitioner would rely on order dated 28/2/25 passed by this court in writ petition number 4557 of 2025. Notice returnable on 1st April. By of head entry limit is directed that if the election, if the motion of no confidence is to proceed, the all further steps will remain subject to outcome of.
Right.
Number 24. The Divya Puran there.
Appellant. This matter had come up last time. Lord Justice Arun had pointed out to me, Lord, as to whether the bank can consider making payment of the bank guarantee amount. I thought I'll be able to get instructions very quickly, but I've not yet got full instructions in this matter. The Lordship grant us some time, Lord.
Yes.
See if we can, I'll try my best to see if it can be resolved on that front.
Tell the date. Date.
Your Lordship may grant us 1 week's time or 10 days' time.
17.
7th April
17.
1/7, yes.
173. Yes.
Number 25,
Serial number
Devraj
25,
case.
my lords, I appear for the
Fresh matter.
Yes,
Delay.
my lords. Yes, my lords, there is some delay.
Notice returnable.
Notice publication.
Second April.
Yes, my lords, the shortest possible date, because my lords, there's some underlying proceedings, but I leave it to my lords, as per your lordships.
Shortest possible date.
Because
is
I'm told, my lords, there is
24th.
20, we are grateful, my lords. Problem. My lords, there's also, may I make one more submission? There is an other appeal also, could it be connected along with that also? My lords? Of course, in this notice is issued, writ appeal number 315 of 25, arising out of the same learned single judge's order.
It is going to be listed on someday.
I don't know, I will move Madidira. Not yet moved. My lords. We'll move it, my lords. We'll move it separately.
Move
We'll
it and then mention.
Yes, my lords. Grateful. My lords, could we take out notice on the counsel who appeared before the learned single judge?
In addition to the notice to be effected on the respondents, learned advocate for the petitioner is permitted to furnish copy of the appeal to learned advocate who appeared before learned single judge on the behalf of the respondent.
Grateful.
This is number 26, Purna Chandra. Here for the appellant's counsel. Matter had come up yesterday, but there was, I think, nobody who appeared on the other side. But respondent's appeal from a section 9 proceeding. My learned friend appears for the petitioner before the commercial court. I am the landlord. The lease is an unregistered, unstamped agreement to run a school. But what happens is that it appears that the respondent voluntarily vacated the premises, handed over possession, and we took possession. There appears to be some video and all of that. I don't want to trouble your lordship with that at this stage. After this, they file a section 9 petition. One of the prayers they seek is that we should hand over possession back, in the sense of seeking for locks to be opened and so on and so forth. The learned trial judge proceeds on a completely erroneous basis. Please be kind enough to take the impugned order, running page 45, internal page 18, my lord, para 4. The point for consideration that is framed has nothing to do with the case. Your lordships may please take running page 45, paragraph 4. But the question is whether the order of interim measure to take possession of the construction equipment to the interim custody of the applicant is to be passed as prayed. Nobody has sought any construction equipment. They want possession back of a school. Well, it's really a house that is being run as a school. They want.
Where is section 9 application?
But the application your lordships would get at page 107 is where it begins. Please be kind enough to see the prayers that those are at 115. Your lordships may please see prayer 1 to restrain respondents or anybody at their behest from interfering with possession. Please see prayer 3 to direct respondents to reopen the locks on the gates. My lord, it can't be both. They're either in possession or they're not in possession. If they're not in possession, their prayer should be one for restitution alone. They can't ask for injunction on the one breath and also ask for possession on the other. Their prayers are mutually contradictory. My lord, is my submission. Now, be that as it may, it is nobody's case that there is construction equipment. So the entire order is, I'm not able to justify anything from the order is what I would submit. Then, my lord, if I may take your lordships further through the order proceeds on the basis of Article 300A of the Constitution, my lord, in a private list between the parties. And my lord, importantly, the lease is unstamped, unregistered. Even if it can be looked at for the purposes of arbitration, the text of the document can't be looked into. Please see the finding that is written by the learned judge. Portions of the lease deed are extracted, paragraph 14 at running page 53. Then, para 16, there is a clear finding that they're in arrears of rent. They have not been paying rent since October. Basically, that said that we are anyway giving up, so you deduct it from the security deposit. In December, my lord, this possession controversy occurs.
Only one respondent is there.
I'm sorry, my lord.
Only one.
Yes, my lords. The school
Yes,
is
only
the
one.
respondent, my lords.
Now, please
The
then be
school is
kind
the
enough to.
respondent, my lords. The school is the respondent, my lord.
Only respondent.
Only
the
one
school, my
respondent.
lord.
And my learned friend appears on caveat. My lord, please then see
Oh.
one more aspect.
Between trust, you are the only respondent. This Keshav Ram Education.
Yes, my lords. Your lordships, if I may, the learned counsel appearing for the appellant has not been too generous with the truth, my lords.
I
Your
don't need to
lordships,
listen to
the
this remark.
entire-
I'm sorry.
Your lordships,
I have
may-
some.
I may be permitted
No,
to
my
file my
learned friend should,
objections, my
this is
lords.
not the way to make submissions. I've not even
My lords,
completed.
okay, okay.
My learned friend should be a little careful
let
in his
us
choice of
complete, my
words. This
lords.
is not fair.
I will file my objections on affidavit.
Fair
my
at
lords.
all.
I will file my objections, my lords.
Please learn to be a courteous to your opponents. This is
My
not the way.
lords, there have been active
What is
supposition of
this?
facts here, my lords.
No, 1 minute,
There have
please.
been
Whatever it may be, please don't point fingers at the council.
No, I'm not
This is
pointing
most
fingers at
unfair.
the council. My lords, I will
Most
be
unfair.
permitted to
Please
file
wait,
my
please.
objections, my lords.
Let him. Let him.
Yes, my lords.
This is not fair. You can't just point fingers at a council like this. Lord, there is more to point out from the order. Please then be kind enough to see what the.
You are showing the prayers.
Yes, my lord. I was pointing out to your lordship from the prayers in the page 115.
150.
Prayer 1 is that there should be an injunction restraining my lord, appellants before your lordship from interfering with their possession. Prayer 3 is to put them back in possession by reopening the lock. And my submission is it can't be both. If it is a petition for restitution, first of all, I have some doubt over whether it would fall within the confines of Section 9 of the Arbitration Act. But even if so, well, it can't be both. It can't be prayer 1 and prayer 3. If their position is that I have dispossessed them, then their prayer should simply be for restitution. It can't be, my lord, for injunction is my submission.
They are running a school.
They are. May I just draw one more aspect to your lordship's attention? Yes.
Can you vacate it by the end of the academic year? Can you wait till then?
Let him make good the rents, my lord. I have no difficulty.
Your lordships, we have already commenced arbitration proceedings. Notice under section 21 has been
Sir,
issued, my
the
lords.
court asked you a question,
Yes, my
answer it.
lords.
We know that proceedings are on.
Yes, my lord.
Yes or no? If you are not interested, we will proceed to pass the necessary orders.
Your lordships, may I be permitted to seek necessary instructions and come back? I will file an objections on affidavit, my lords, regarding this particular appeal, my lords. This is a kindergarten school, my lords, where children only up to 3 years are admitted, my lords. Before the school was closed, there were 28 children, my lords. On 31st of December of 2024, my lords, the appellant.
Admittedly, it's an unregistered lease deed.
Yes, my lords. Yes, my lords.
After 1 year, you're a tenant holding out.
Your lordships.
You're a tenant holding out. Under the given circumstances, the court asked you a question.
Yes, my lords.
They will permit you to stay till the end of the academic year.
Yes, my lords.
By the end of the academic year, are you willing to vacate the school? Your mutual, what do you say, monetary thing, you can
Yes.
fight it out in arbitration.
Yes, my lords.
Yes or no?
I may be permitted to take instructions from the
Okay.
client, my lords.
Who is in possession today?
As of today, on 26th February, we re-entered possession with the assistance of the jurisdictional police station, my lords.
Please see the operative portion of the order at page 63. The direction is given to me to hand over possession back to them with the assistance of the jurisdictional police, which means they have again forced their way in, my lord. It is obvious because they were admittedly at the date of the petition not in possession. My learned friend was also candid enough.
They are asserting possession at page 110.
My lord, yes, but please see their prayer. They say that we've been dispossessed. My lord, I'll point out to your lordship.
Right, that's right.
That's correct. Now, my lord, order would say that I have to hand over possession back to them. I have preferred an appeal before your lordships. In the meantime, they go and take possession back.
And what remains?
My lord, my respectful submission is that this order therefore is, and them acting on it is totally
Then
opposed to law. They can't, my lord, they point fingers at me. They have not paid rents from October. And my lord, they want to forcibly enter back. They say children, but this is not what children ought to be taught. Therefore, my lord, anyway, what fell from my lord, your lordships, that if they can vacate and go, no difficulty about it, that puts a quietus.
correct.
That puts a quietus.
Your lordships, kindly let me take instructions from my client and help. And an opportunity may be granted for filing objections, my lords.
Take instruction, file objection, do both together.
My lords,
Yeah, I
it
mean-
was earlier posted for 11th March, my lords. If the same date can be fixed for the next date of hearing.
6th and 11th March, at the request of learned advocate Mr. So-and-so. Send out 11th March to enable him to necessary instructions as to whether. So we're recording that you take in order to, in order.
Yes,
to
my lord, please.
enable the
Please.
Respondent to take instructions. To enable to file reply as well as to take instructions.
Okay.
Inter-alia as to whether the respondent school is ready to vacate.
Please,
the school
by the end of the
premises
academic year, as my lords.
After the end of the current academic year.
I'm so grateful.
Yes, my lords, I'll take instruction.
So everything can put it. Very, very right suggestion of my brother.
I'm very grateful, my lord. Very grateful.
So unnecessary.
Even in the other matter, my lord, what fell from your lordships, we are in mediation. That is, my lord, ultimately what is the right course for any such case. So great.
Much good. Number 27.
I appeal for the appellant.
The caveat respondents, my lords.
This is an appeal, my lords, against dismissal of my section 9 petition for interim measure, my lords. The dispute arises out of an LLP agreement, my lords. Initially, my lords, the commercial court has granted an ad interim ex parte order, directing them not to make unauthorized communications on behalf of the LLP, either to ICOM Motors or any other supplier or vendor of the LLP petitioner number 1, my lords. Now, my lords, after hearing, my lords, the matter was referred to mediation twice, my lords, during the course of proceedings. Then, my lords, finally it is dismissed on the ground that we have not initiated arbitration proceedings within 90 days of filing the Section 9 petition, my lords. If your lordships will see Section 9 for a moment, my lords.
My lords, we'll have to file objections in this matter, my lords. For the caveat respondent, my lords.
It was
we
listed on 25/2. On the last date also, they made the same submission. They had given an undertaking that they won't precipitate the matter from their side, my lords. That is why it was listed today from 25/2, after the court heard for, the matter for some time, my lords.
My lords,
Today on time.
please, my lords.
Twice at their request, the matter was referred to mediation, my lords.
My lords.
Twice at their request, the matter was referred to mediation and I had the benefit of the interim order throughout, my lords. And that too, it's an innocuous interim order, my lords, not to make unauthorized communications on behalf of the LLP. That's all we are pressing, my lords.
My lords, will be, in our statement of objection, we take the objections that such an interim order could not have been passed in the first place, my lords. It was done on the suppression of material facts and documents, my lords. It will be placed on record on the next date of hearing when we file our statement of objections, my lords.
Why do you want time?
My lords, to file a statement of objections, my lords, it's ready, my lords.
My lords, may I make one submission? On the last date also, they had agreed they won't precipitate. Let that continue, my lords. That's all I'm asking.
It was not recorded.
Let them
in the
not make
order.
any, my lords, the senior counsel appeared and he undertook, my lords, not to precipitate the matter. Let them not, let that be recorded.
When you're seeking time to file
Yes,
the
ma'am.
reply, don't precipitate this.
Please, my lords.
So we'll not record. It continues.
Don't need it.
Assurance.
My lords, let it be recorded, my lords, because they have threatened in writing, my lords, that they'll make unauthorized communications and breach the confidentiality agreement. I've produced all those emails, my lord. Emails and WhatsApp communication. That is why the trial court had granted an ad interim order, my lords. Only on the ground that arbitration is not initiated within 90 days, it was vacated, my lords.
The present appeal arises out of order.
My lords, if
Dated 3rd February 25, passed by learned the 6th. Additional civil instances to commercial court Bengaluru, whereby application under section 9 of the Arbitration Conciliation Act 1996 filed by the appellant hearing came to be dismissed. What was the interim order operating during the pandemic?
That they were restrained from making unauthorized communications on behalf of the LLP, my lords. I have the certified copy of that.
my lords, a
Okay,
legal
let the-
obligation exists on the appellant themselves, my lords, by way of a document they suppress before the trial court and this honorable court to communicate with ICAR Motors
When
in
the
the
appeal comes
event
up for
that
cons-
such litigation exists against the appellant.
Today when the appeal,
If my lords may be, if I may be permitted to just produce
today
that
when
one.
the appeal comes up for consideration, learned advocate Mr. So-and-so press time to file a counter. Full stop. While not objecting to the said request, learned advocate for the appellant submitted that on the last occasion when the appeal was considered by the coordinated bench, there is an oral assurance made by counsel to the respondent.
Yes,
Will
ma'am.
not precipitate the action.
Yes, ma'am.
Full stop. Since today time is asked for by the respondents to file a reply, the sale oral assurance will continue. And it is provided that no precipitated actions will be taken.
Much of.
Till the next day.
Till next date of hearing. My lords, a date may be given, my
A
lords.
date may be fixed.
When do you want?
My lords, preferably 20th March, my lords,
21st March.
21st March.
23, my lord. Sorry.
My lord, 21st, there's some inconvenience. May I request for 20th or 24th, my lord?
24th.
24th, much of it.
Sorry, lordship, the 23, lordship, I am hand delivering in time.
And which is the number?
20.
That Gram Panchayat.
Sorry.
Summons by,
Contempt.
service by and delivery is permitted.
Please.
Today is permitted.
Please.
Yes.
So 28, 29 are urgent. Seal number 30. The Surrogacy charity.
Lordship, I am
Number
appealing for
30.
respondent 2 to 7 in writ appeal and complainant in contempt case, my lordship. First occasion was heard some.
Here for the appellant.
Lordship, it is a fit
But
to.
the preliminary notification for the purpose of further extension of 6-stage Banshankari layout was issued in 7/11/2002, Lord.
Actually, it's a fit case,
Amal-
deserve to be dismissed with cost, my lordship. Fourth round of litigation, my lordship. Spot inspection was also made twice.
Lord, and final
As per the first honorable court order direction, last may I kindly come to writ appeal, my lordship. That is page number 142. Writ appeal, kindly come to page 142. The respondents filed a writ petition 9/24 of 2004. In that case, 20 years back, action was issued by this honorable court. Wherever the buildings were there, it has to be left out. According to the direction, the BDA has passed through the resolution, my lordship. BDA has passed resolution. Board resolution, it is at Annexure G, my lordship, 278. According to draft the proceedings, then again, lordship, this honorable court has directed to make joint measure
Giant merger was made. This is a small pocket of land, 30 guntas. The entire surroundings, there is no layout formed by the BDA. The report is there. The BDA officials, engineers twice came to the spot and visited and said there is no surroundings, entire surroundings, there is no layout. As may kindly see, we have constructed the building before preliminary notification. In the merger report, it is clearly stated, the houses are there, the poor farmers, they are residing in the said houses. The Honorable single judge has passed an order to not to dispossess them and restore the possession, but possession was with the respondents only, because the merger also clearly stated that the respondents are residing and construction of buildings are there. In the similar matters, my lordship, this honorable court, in the same layout, has passed an order. If it is a small pocket of land, it has to be excluded. In the similar matter, the same court has passed an order, my lordship. I'm having the citations also.
Notice is issued.
Notice is issued, not they filed objection. Not-
Yes.
Please, note on 7/11/2002, a preliminary notification was issued for the formation of further extension of 6-stage Banchankri layout. Not the land of the petitioner was a part of the notification. Subsequently, a final notification was issued on 9/9/2003. Blood. And award is passed on 20/12/2003. Possession of the property is taken over on 7/1/2004. But this issuance of the preliminary and the final notification, the petitioner along with several other landowners challenged the acquisition proceedings before this honorable court. May I request your lordship to kindly take page 126. This is the order of the learned single judge. Blood. There is a batch of writ petitions which were challenging the preliminary and final notifications issued for that. Relevant page would be page 142. Blood, the writ petition, blood, 9/24 of 2004, blood. Venkatraju, Ravi Kumar, Manjunath, Indrani, Radhama, the very same petitioners, had challenged the issuance of the preliminary and final notification. Lord, may I request your lordships to kindly take, Lord, the page 203 of the writ appeal. Lord, this will show as to what was the challenge before the learned single judge in 2004. These writ petitions are filed by the landowners, site owners, and the interested person challenging the notification issued under section 17(1) of the Bangalore Development Authority Act, dated 7/11/2002, bearing numbers so and so, published in the official gazette on 31/11/2002, and the notification issued under section 19(1) of the BTA Act, dated 9/9/2003, dated published in the official gazette on 10/9/2003, called as a final notification. By issuing the said notification, the Bangalore Development Authority proposed to acquire the land specified therein for the formation of a layout called as a further extension of Banchankri 6th stage. Lord, this was challenged by them. Subsequently, Lord, may I request your lordships to kindly take, Lord, 214, the findings of the learned single judge. Lord, some of the findings, Lord, the observations. Lord, after points for consideration, Lord, the above points, contentions raised in behalf of the petition, 214.
So these are the same notification, earlier.
Same notification. And very same petitioners had challenged. This has attained finality insofar as they are concerned.
Same petition, sir.
Same petitioners had. That is what I pointed out.
Yes. next.
Yes. The above points, contentions raised on behalf of the petitioner opposed by Sri so-and-so learned counsel appearing on behalf of the PDA, inter alia contending that there is no discrimination or arbitrariness in acquiring the lands of the petitioners and deleting some of the lands belonging to certain other people, that the authority has proceeded to issue final notification after complying with all the statutory requirements, including hearing of the petition. He further brought it to the notice of this court that the sites are already formed and more than 80% of the sites are already allotted to the applicants. Crores of rupees is spent for developing the lands, for formation of the roads and drainages, etc. And that therefore the acquisition proceedings cannot be quashed at the fag end of the scheme. He further submits that only 25% of the area acquired is under litigation, and in these petitions, and consequently the owners of the 75% of the lands sites have been accepted the acquisition notification. Lord, now, Lord, may I take your lordships to Lord, page 224, Lord. Point number 12, Lord, of the learned thing at the bottom, Lord, page 224. Point 12. After considering the objections filed by the landowners and the interested persons in response to a notice issued under section 17(5) of the Act, the authority has rejected the objection in respect of the lands to an extent of 750 acres and submitted the scheme for the necessary modifications to the government under section 18(1) of the BD Act. And only such lands are included in the final notification by dropping 782 acres of the land. In these matters, an extent of 22 acres, 5 guntas are denotified even after publication of the final notification, solely on the ground that the said lands are converted lands, that it is not economically viable for the BDA to acquire these lands. However, the records disclose that the modified scheme is already implemented in its entirety by the BDA by developing the lands and by forming sites. As aforesaid, 80% of the sites have already been allotted to the applicants at large. Under such circumstances, it cannot be said that the scheme itself cannot be implemented. Now, Lord.
Again, it was challenged. It was again challenged.
He challenges, comes before this honorable court again on a direction. Lord, may I request your lordships to kindly take this direction, operative portion. Lordship may kindly take page 270. Yes.
See, this is a land of around how much? 34 guntas?
34 guntas.
34 guntas of land.
One more thing, I'll bring it to your lordship's notice. The learned single judge, finding of the learned single judge with regard to a petition, my lord, where the order has been set, the acquisition is set aside in respect of that one particular portion of the property. My lord, the BDA is filing an appeal in that also, my lord. In a day or two, the appeal will be filed.
So Justice
One.
Shantanu Gowda's
Order
is challenged, is
No,
it?
no, my lord. Justice Shantanu Gowda's order is challenged and pending consideration in a writ appeal. Not in, by 11 of the landowners.
It has not attained finality.
It has not attained that has attained finality, but in respect of those properties, not they are in before the learned division bench. Only that has that is there. But the fact that, my lord, the learned single judge directing us to redeliver the property back to the petitioner, my lord, is what is not permissible under law, is my respectful submission.
No, the status of the property is it is only 34 guntas.
Yes.
It is like an island.
It is like an island. As
There is no contiguous, it is not attached to any of your other BDA layouts.
The fact that it is attached to a road, BDA road, which is formed by the BDA, which passes through all these survey numbers, those which are already deleted also.
That's okay, but it is not attached to any BDA layout.
No,
it
will.
It's like an island.
It's just, right now it is an
No,
island.
that's your recommendation at
Yes,
page number 16.
Yes, it is now an island because the one of the survey numbers which has been set aside by this honorable court, but we are filing an appeal. If that also becomes, Lord, these two properties can be utilized by the, even if not by the BDA, by the state for any other public purpose.
No, why did you at the first instance recommend for deletion?
But this recommendation for deletion was analyzed by the state government. State government rejected my recommendation stating that, kindly note that also is a part of this document. Lordship may kindly take annexure K, page 306. Before that, Lord, the order of the learned single judge, Justice Shantanu Gowda's order, I will have just point out the directions as to how the BDA and the state government ought to have considered the case of the landowners for deletion. Lord, it ought to have been fully built up as on the date of the preliminary notification. By Lord, then the state government takes a note of the facts.
Now, have similarly situated lands been deleted from acquisition?
Lord, totally built up, this is not a totally built up land. And the acquisitions were completed. And so far as other lands are concerned, acquisitions did not continue. Those lands at their request were left out. Lord, that is then the case. Here is a case where only the temporary sheds are found when the Google Maps were taken by the state government, not by me, Lord. Lordship may kindly take annexure K, Lord. There's a finding of the state government that this was not completely built up. Hence, you are not entitled for a deletion as per Lordship Justice Shantanu Gowda's order. That is the finding. That is what is the endorsement.
At least the area where it is built up.
Lord, it is not built up, Lord. The temporary sheds are there.
Whatever they are living over there.
Lord,
that area can be excluded. You can be.
Lordship may.
Recent merger also, twice merger has been made as per the direct issued by this honorable court.
I'm agreed with this finding.
It's clearly stated, it's entire surroundings though, even 16 Bharati south side, it has.
He is not disputing that fact. The fact is your land is not built up, number one. And there is only, you put a small shed and you are living in it. The question posed is, can that area be excluded? Some via media. They are also happy.
Even there is no 16-2 notification.
35D,
they are not issued.
38D, 38D is there. Lord, that was a.
Do something under 38D.
That's
Lordship may kindly see, one in my statement of objection, I had, Lordship may kindly see that. I had said, if they are coming within the purview of 38D, Lord, they can even exercise. They can avail that benefit. Para 13 of my statement of objection, I proposed it.
No.
Lord, now directing us to redeliver the property, Lord, is, Lord, once it is vested. Now they cannot say that it is not vested since they have accepted the order of the learned single judge, or where the direction is there. And a contempt petition is filed saying that I am disobeying the order of the learned single judge and not handing over the possession back to them. But now they cannot in a writ petition content, writ appeal content.
Compensation amount is lying with you or is withdrawn?
It is there in the civil court. It is there in the civil court.
They have to issue NOT, my lordship.
Reference court.
Lying.
Yes.
Lordship make one submission, my lordship.
This did. You need to. But here, this one, it's only temporary. The entire surrounding area is built. It is like an island, not attached to any other area. The lower can be found. As waiting. And initially, video also recognition.
Lordship, no demand notice has been issued, physical possession not taken. And even 16(2) notification was also not published, my lordship.
Video wanted to withdraw, the state did not permit. It's interesting first to take a look. The video can- That's why for the purpose. Maybe even there. It's in recommend.
Lordship, in similar matter, in the same layout, this court has passed an order excluding the small packet of land. I'm having that citations, my lord. The same layout, same.
They decided not to accept this.
Similar matter, similar situation, this court has passed an order in the same layout, Panshankri stage. It's a small packet of land. This court has passed an order to
Not a bunch.
exclude the land, my lord.
You copy to your. Not Panchayat 6 stage, it's Panchayat 6 stage, further extension. Others. That is. Out of.
See, under the given peculiar facts and circumstances of the case, now we have a scheme of 60-40
Please.
instead of monetary compensation,
Yes.
right?
Now, for the, only for the 3 layouts we have it, not for the other layouts we don't.
It's a suggestion being
Yes,
made.
please.
If they give you compensation on 60-40 basis, I think you should be happy with that.
Lordship, even 16(2) notification is not published. Possession not at all.
I'm
taken.
asking you a question. Are you open for considering it?
Lordship,
See, instead of monetary compensation, the amount that was deposited way back in the year 2003, which would be pittance as of today. The present policy of the BDA is giving compensation on 60-40 basis, land sharing basis, developed land sharing basis. If that is granted to you, I think you should be happy with it.
Lordship, may kindly see the entire surroundings, there is no BD layout. Kindly see, my lordship, our approach road illa Swami alli. Merely in the Tagondru Koda is a small packet of land. ಇಲ್ಲ ಇದ್ರಲ್ಲಿ ಬರ್ಬೇಕಾಗ್ತದೆ.
English is the language of the court, Mr. Counselor. You need to understand that.
And even 16/2 notification ಆಗಿಲ್ಲ. So there is no 16/2 published. They are not taken physical possession. The engineer's report clearly says they have not formed any layout in 30 guntas. The report given by the engineers, it shows clearly that they have not formed any sites in the small packet of land. They have not issued any demand notice to take possession, my lordship. They have taken only symbolic possession. The landowners are only residing in the houses, my lordship. They are poor farmers. Except that land, they are not having any land.
Hear at length. We'll hear at length.
Please.
1st April. 1st April.
Please.
1st April.
1st April, please.
Lordship, a short date, my lordship, because
Till
20
then.
years, fighting from 20 years, first to come with 2004, my lordship.
Till then.
First writ petition was filed in 2004. Before 2003, they have constructed the building. They themselves have produced the documents from me. They have produced that we have to get license, everything. Short date, my lord.
Lord, may I request for a status quo at least till then, Lordship may protect status quo. Lord,
Are you going to file some contempt? Contempt is filed.
My contempt petition is also
Alienation.
pending, my lord.
Alienation.
They have not filed any, counter to my contempt petition.
You are in possession.
They have not filed.
Lord, the learned single judge says that I should hand over the possession back to them. That is the finding of direction.
You are in possession.
Yes, yes, we have taken possession of the property.
So then
Lord,
what in?
Lord, some alienation based on this order, Lordship, may status quo at least to that.
Who will alienate?
If they make, Lord, then they'll come and say we have changed the status. That should not happen. That's why, please, I leave it. Please.
Very direction of learned single judge says that you are in possession.
Yes. Yes.
We can say that. Paragraph.
Lordship, may kindly take the operative portion. Para 13, Lord, page 21. The BDA is directed to restore the possession of the said land in survey number 16/1, measuring 34 guntas to the petitioner.
Lordship, the report of the engineers very clearly state they have not formed any layout at all. They are not formed sites at all. That's why the single honorable court directed to make a Mahajar report and Spatition joint Mahajar also.
To 1st April 2025, learned senior advocate Mr. So-and-so for the appellant BDA request for interim order. Full stop. The very directions issued by learned single judge indicate that the appellant BDA is in possession of the land of the plot, site, land of the property in question. In view of that actual position, no interim order is required.
Great. Please,
Covers everything.
please. Okay.
Silma 31, Mr. B.V. Patil.
With your lordships kindly. Lords, there's a delay, my lords, and a notice was issued, and we have served a copy of the delay application along with the main memo.
Delay.
Please. Main memorandum of appeal also is served, my lords. There's a delay, my lords, due to certain administrative exigencies within the department in securing legal opinion and forming an decision to file an appeal as such, my lords. There is no formal objections filed to my application as such.
File my objections, a week's time may be granted.
Connected appeal, my lord, where 848.
First April. In order to enable learned respondent to file objections to the delay condonation application.
Obliged.
Connected appeal, my lord, 848. I'm appearing for the appellant's counsel. There I sought for a leave, my lord. That leave may kindly be granted and matter may be heard.
On
along
that
with
day we'll see. Leave.
Deeply obliged.
Both together.
December 32, say state appeal.
Delay of 71 days.
My lord, notice has been ordered in this matter, my lord, on last
It
occasion.
is already ordered.
Ordered, my lord, 71
appeal.
days delay is there. Lordship may kindly condone that and post it for.
Shaker,
Object to the delay, my lord.
71 days.
My lord, I have actually been targeted, my lord, specifically. This is my 5th round of litigation, wherein in the previous 4 rounds, no appeal has been preferred. They have attained finality. And in this 5th round of litigation, they have preferred an appeal, my lord. I have sought for regularization of my services.
The writ appeal is proposed against judgment and order dated. The writ appeal is proposed against judgment and order dated 15/4/24 passed by law in a single judge. Whereby the petition of the respondent herein, writ appeal is proposed to the state. Further, whereby the petition of the respondent herein was allowed. Endorsement dated 8/2/23 passed by respondent 2. That's the Commissioner, Department of Social Welfare, set aside and direction of the suit to reconsider the petitioner's case for regularization by adhering the law laid down in the Supreme Court in the court. Secretary, State of Karnataka, versus Kumar, 2006 4 page 1. In filing of the appeal, delay of 71 days has taken place. Therefore, the appellant applicant state has filed the present interim application, present applications praying for condonation of delay. Our learned additional government advocates, Mr. H.S. Harish, and learned advocate Ms. So-and-so for the respondent or in petition. The passage of time leading to delay to the extent of 71 days is thought to be explained in the accompanying affidavit, wherein it is stated inter-alia by the applicant state that after deliverance of the judgment and order of non-dismissal, legal opinion of sort after full stop, after receiving the legal opinion, the matter of central department to the head of the legal cell. After government order 4724 was issued for preparing the writ appeal. So stated that the same was received by the office of the court building. From whereafter the appeal was declared and was filed. The time consumed is in the administrative process. So the applicant is state and impersonal body, therefore decision-making process invariably consumes some time. Viewed from this angle, viewed from this standpoint, it could be said that sufficient cause is made out to condone the delay. There is no element of indolence or negligence. Paragraph, interim application is allowed by condoning the delay of 70. Now, what about the, want to argue
Kindly
today?
have it next week, my lord.
Next week. Second appeal.
Because there's a connected
Appeal
note
to be
also.
listed on second appeal.
Any short date, my lord? Would it be possible for a short date, my lord? Because it's
When-
my fifth round. My only request is my fifth round for the same issue.
24th.
Great.
So number 33. Mr. Ranganath S. Joyce.
That's I appear for respondent number 5, my lords.
Number 33, Mr. Ranganath S. Joyce.
Nobody is there. Keep back.
So number 34. Mr. Satish K.
Matter pertaining to transfer. The petitioner, appellant, who filed this writ appeal, was initially appointed as field officer under the comprehensive scheme lot, trading for cost cultivation introduced by Government of India. My lord will find the appointment order at page 85. 85. Next, page 85, my lord, type of copy is also there. The first paragraph itself, my lord, would indicate that. The Vice Chancellor of Agricultural Science Bangalore is pleased to appoint Jagannath Olekar to the post of field officer, cost cultivation scheme, Hebbal, Bangalore, temporary until further orders. It's a specialized post in the central government scheme. Without consultation of from central government, none of the staff can be diverted. Not then.
So here there is no question of an interim leave.
What?
There is no question of an interim leave.
But it's a case where, my lord, I am transferred, my lord, to the post of professor. I am, my lord, associate, but there is no post existing in the, my lord, Mandya University. Now, my lord, Mandya Veterinary Science also became an independent university. Recently, my lord, last week.
Appeal may be listed for, appeal is admitted, it may be
My
listed.
lord, question is, my lord, I have no salary, my lord. That's why, my lord,
Granted, finally, it will amount to granting final relief.
no, I'm not, I'm only requesting your lordship, my lord. But I have no salary for the last 7 months. But kindly appreciate this, my lord.
That's July. Lord, we
My
issued
lord, though there is an interim order for the learned single judge, they did not pay the salary.
my land fund has suppressed the fact, my lord, even before learned single judge also. Kindly, my lord, Anesh Sharia, page 85, top of the direct recruitment of teachers in the cadre of assistant professor. We called for the professor post, assistant professor post. He submitted
Yes,
the
my lord, if he's
application.
ready, I will argue the matter.
1 minute, please.
Just time, my lord, I will argue the matter. There is no difficulty at all. Absolutely no.
Everything is recorded.
You know,
On
he
inter-
cannot say that petitioner or appellant has suppressed the fact. But he cannot say so lightly. He is appearing for you.
26
He is appearing for the authority. He must not make submission with responsibility. Not kindly see annexure for a moment. He was appointed as a lord to the post of lord field officer, cost cultivation central government scheme. My lord will find he has reported duty there. Thereafter, my lord, the post of field officer is upgraded. Kindly see, my lord, page 96. Item 21. He has been continued there. Then, my lord, annexure, lord, the earlier occasion, lord, the petitioner was transferred to the same university, annexure F, page 31, 523. 1 minute. Page 109. As assistant professor, lord, same VC form, Mandya. This page 109, lord. My lord will find the English version 112. Lord, kindly see annexure G. Central
those who are posted, Jagannath Olekar is posted central government scheme without the prior consultation, not staff shall not be shifted. Can you see Annexure G page 1?
Come to Annexure A first.
Yes, Lord. Yes, Lord.
Subject, direct recruitment of teachers in the cadre of assistant
Yes,
professor.
my Lord. Yes, exactly.
Now, the university invited applications for the post of assistant professors. And you made an application.
Assistant professor in the scheme. In the scheme. It is called field officer. Can you see that also? They have produced cost cultivation scheme. Lord, they have produced that notification also. My Lord will find that notification. Kindly see, my Lord, R1, page 164. But question is not that. My Lord's question is, if I am transferred to equivalent post, I have no case. I am transferred as assistant professor in the earlier occasion, where there is no post of associate professor is existing. Now, I am transferred as a professor on own OPG basis. Is it permissible under law? Is the question. Whether I am a field officer or professor is entirely different. But kindly see now, the earlier occasion, when he approached the court, it is a bona fide transfer order. My Lord will find annexure F, my Lord, page 112, 130-15-2023. My Lord, he was transferred as assistant professor in VC form, Mandya. Kindly take my page 112, my Lord. This was questioned by me. Kindly take annexure H. History of this case, my Lord, is a bona fide transfer order. Kindly see annexure H, my Lord. The university admits that there is no post of associate professor. Annexure H, my Lord, the very order is questioned. 117, my Lord. Kindly see. Lord, got it? 117, para 4, my Lord. Per contra, learned counsel so and so. Respondent should be sought justify impugned order transfer. Submitted that this court as having limited jurisdiction to interfere with the transfer. Accordingly, he sought for dismissal of the petition. Further, he submitted petitioner herein being an associate professor and under career advances can be posted his own OPG vacancy at the entry level assistant professor. Original appointment of petitioner. That assistant professor accordingly sought justify the order. In the light of submission made by learned counsel appearing for the parties on careful examination R2, it is reflected that there is no sanctioned post of associate professor. Kindly note it. Kindly take note 117 associate professor in agricultural economics, BC form India. In that of the matter, it is well established principle in law, no transfer could be made by the employer to unsanctioned post. Further, transfer of petitioner for the post of associate professor to lower contrary to law. Accordingly, it is quashed. But thereafter, the present order of transfer is passed. Kindly see very strangely.
We'll hear it at length on 3rd of April.
Not
on 3rd, we'll hear it.
If your lordship is preoccupied with the work, I leave it to court, but I cannot say. But I have no salary for the last 7 months. There is a day order before the learned single judge.
I won't interrupt my learned senior counsel. Everything is, my lord, recorded by the learned judge, collected the information, teaching, research and extension. Every teacher, my lord, in agriculture university.
But salary is not paid.
No, my lord.
Salary,
this court stayed the interim order.
He has posted against the sanctioned post of professor only for the purpose of drawing the salary. His grade is not changed. Position is not changed. Salary is not changed. He has to report the duty, my lord. Otherwise, we cannot.
But I cannot report a duty where no post of associate professor is existing. Transfer is permissible. I am posted as associate professor. I will go and report duty.
126 posts.
Law is settled in transfer matter.
Blood, including Mandya, June 30th, 2 teaching faculty retired, an interim measure on his own pay and grade. We have been transferred, my lord, for the interest of the safeguard the interest of the students. 126 seats are vacant. It is recorded by the learned single judge. And my lord, he is having the experience. He is an associate professor. There is no sanctioned post of associate professor. He transferred against the post of professor.
No, matter is covered by decision of Supreme Court.
Reported duty. My students are suffering like anything, my lord.
Associate professor can be transferred to associate professor, not any other
Against the post of
On 12th, you may hear and put in.
My lord,
12.
12th, very well, my lord. I am
12th.
ready. Everything is recorded by the learned single judge, my lord, before the.
12th, we hear put in.
my lord, the difficulty is, my lord, even though there is an order of stay before the single judge, my lord, there is no salary is paid. My lord, how to
So,
educate my children?
It's a matter of 1 week.
Transfer orders, my lord, it is.
If the
taken-
transfer order between the same cadre, my lord, I would have gone and joined duty.
But you
Sir,
are
it
not
is-
joining duty.
Yes, my lord.
So we'll take up the matter on 12th and dispose it.
Please, my lord.
Either way, 12th. You give for reading.
But on 13th, my lord,
13th is not working, holiday.
14th, my lord, 14th.
14th.
Because 12th, my colleagues, my lord, engagement day, my lord.
14th.
Otherwise, my lord,
At the 14th.
So number 35, Mr. Saravana, yes.
The petitioner in this case, my lord, a short accommodation, senior inconvenience. We have engaged senior counsel in this matter, my lord.
Why you are seeking time?
My lord,
Why you are seeking time?
we have engaged senior counsel in this matter, my lord.
Senior counsel.
Short accommodation due to personal inconvenience, my lord. Kindly have it next week, my lord. A date may be fixed, my lord.
Tenth.
Next week, any date, my lord. I
10th.
apologize.
10th.
Please.
You can argue.
I don't have any instructions, my lord.
10th. Please.
Grateful, much.
Number 36, KMC Basuraj.
I appear. Not the appellant is a retired employee of the corporation, lord, working as a conductor. At the time of retirement, lord, his terminal benefits was calculated and it is found that lord, he was paid excess salary of rupees 1,87,000 and that. Then therefore, my lord, the corporation has directed to remit the said amount and take the terminal benefits. As per the direction, my lord, the appellant has deposited the said amount and received the terminal benefits. Then, my lord, it is impermissible in view of the judgment of Honorable Supreme Court, my lord. The recovery is impermissible. Lordship, this is covered by the decision of Honorable Supreme Court, my lord.
So what was the case in the petition? 8 years. So recovery was
Impermissible, my lord.
Hmm?
Recovery is impermissible in view of the all
But
done by
after
Honorable Supreme Court.
recovery for what, Mr. Counsel?
Recovery of recovery, my lord, on the ground that, my lord, you was paid excess salary. While granting the increment, my lord, there is a variation. Therefore, my lord, they have ordered to recover some 1,87,000 from his terminal benefits. The learned single judge, my lord, without
You have said anything about delay?
my lord, in fact, my lord, after receiving the
Petition?
terminal benefits, my lord,
No,
he
no, in
made a
the-
representation as per annexure E, my lord, page 43.
No, anything, what you have said about delay of 8 years in your petition?
Yes, my lord,
Nothing.
Annexure E is the one of the representation made by the appellant.
Where is the averment?
In para of page 5, my lord. Page 5, my lord.
Hard learned advocate, Mr. So and so for the appellant, the appeal is directed against judgment and order dated.
Right, this is covered, my lord. Has been held that, my lord, recovery is impermissible from the class 4 employees, 3 and 4 employees. What should kindly see.
Judgment and order of learned single judge dated 16th December 2024, whereby learned single judge has dismissed the petition on the ground of delay and laches, full stop. The order paragraph, which was thought to be impugned in the writ petition, was dated 26/2/16, passed by the divisional establishment, which was a divisional establishment order. Passed by the assistant administrative officer. The order sought to recover certain amount from the petitioner on the ground that it was wrongly played or wrongly paid. Full stop. Turn a single judge, while dismissing the petition, observed thus the bracketed portion on page 13. In the present case, Vasileke, discretionary. Full stop. When the memorandum of petition is seen, comma, no averment was found. Regarding the aspect as to why the petitioner whiled away long 8 years before approaching the court by way of writ petition. Full stop. The only averment is that the representation was made on 15/6/17 to the second respondent.
In para 5 of my writ petition, my lord, I have
Even
read it.
after, para,
In para 5, my lord. Page 17.
same, full stop. Even after the said representation, 6 years have, long 6 years have passed, 7 years have passed. Petitioner was in deep slumber. When there is no explanation, the filing of representation will not therefore lead the case of the petitioner to anywhere insofar as the aspect of delayed approach to the court is concerned. Paragraph. Writ jurisdiction is an equitable jurisdiction. A litigant, a person who is indolent in asserting his rights would lose right to relief. Full stop. Unexplained delay of 8 years is too long and unreasonable to be countenanced for grant of any relief to the petitioner. Learn a single judge paragraph was eminently justified in observing that delay would disentitle the petition to seek any relief, and that the benefit of a judgment relied on would not be automatically granted by overlooking the delay. Petitioner was never serious about enforcement of his rights. He slept over for 8 years. Full stop. In the circumstances, paragraph. No error could be booked. in the order of learned single judge, comma, interference is not warranted in the appellate jurisdiction. The challenge fails, the appeal is dismissed.
Seal number 37, the G.R. Mohan.
What is it? 2000.
Matter pertain to the removal of encroachment on the Vrishwavati River Valley. Your Lordship passed an order on 13/11/2024, Your Lordship, 13 November. Detailed order was passed.
That's on the last date.
Last 13th November.
My lordships had asked both the BBMP and government to coordinate together their efforts to ensure the encroachments on the stormwater drain are
Paragraph
removed,
5.
my lords.
Para 5.
Encroachment on?
Stormwater drains are removed, my lords.
Paragraph 5, Your Lordship, of 13th November.
This was heard earlier.
Yes, my lords, and I have, BBMP has filed its affidavit in this regard, wherein the joint committee report is also placed between both the government and the BBMP, my lords. If my lordships
22nd
may
November
turn
they
to
filed it.
page 3 of my affidavit, which was filed on 22nd of November 2024, my lords. This is in consequence to the order which was passed on 13/11.
What is 13 November order?
Order of 13/11 had asked us to file a
13/11.
compliance affidavit. I filed it on 22nd of November, my lords. Page 3 may kindly be turned to. May I read, my lords?
Wait, one second. Yes, where is your affidavit now?
My lords, affidavit was filed on 22nd November 2024.
22nd August, 27 November.
27/11, yes, my lords. Page 3, my lords.
27.
22nd, 22 November 2024, yes, my lords.
So that is the last affidavit.
Yes, my lords. Page 3, my lords.
Yes. What is it?
The government in this regard has issued notifications. This is in reply to the para number 5, which was passed on the order dated 13/11/2024, my lords. At para 5, my lordships had passed the order. Both the authorities are directed to demonstrate by filing affidavit before this court their concrete action taken with regard to the directions of removal of encroachment and the joint action plan before the next date. This affidavit from the BBMP is in reply to that, my lords.
Council,
My lords.
Section 104 of Land Revenue Act.
Yes, my lords.
Does the jurisdictional Tahsildar have the authority to do it?
Yes.
Yes, my
Or
lords.
the Deputy Commissioner has to do it?
Yes, my lords.
After the recent
No, the
amendment?
Tahsildar has the, Revenue Department has the authority to conduct.
Revenue Department, correct, but in your affidavit, you have said complaint receiving authority and orders passing authority. The
Yes, my lords,
jurisdictional
I'm coming to that.
Tahsildar.
I'll explain that as well. It's all part of my affidavit. I have also shown how.
No, the
section-
moment Tahsildar issues a notice, they approach this court saying that Tahsildar is not the authority, it is the Deputy Commissioner. The recent amendment, what is it?
Tahsildar has, the role and responsibility of the Tahsildar has now been given to the special DC, who's been appointed by a government order, my lords.
The earliest order is 28 July 2022.
No, should it not be under section 67 of KLR Act rather than 104?
104 is where the inquiry is done. Section 64 gives the ownership of stormwater drains to the revenue department, my lords.
See, this is where you suffer.
My lords, kindly turn to page 4, my lords.
I mean, get the recent amendments that has happened to 104. Probably a jurisdiction over there.
I'll check that, my lords.
You have amendment? 104. Section 104.
Government.
My lord,
See, section 67 and 104.
Yes.
Now, I don't know about the recent amendment that took place,
yes,
but at least as on November 2024, when you filed the affidavit,
Hmm.
Tahsildar did not have the jurisdiction to do what you have conferred him by way of this particular affidavit. It was the deputy commissioner who had to do it, 67 clause 2.
yes. Yesterday also I had brought to to the notice of my lord. It was under, proceedings had been initiated under section 67(2), and then my lord, the deputy commissioner under section 136(3) had passed the order. My lord, in this case also, my lord, the special deputy commissioner, my lord, I have kept them present before my lord, the Tahsildar Bangalore North and Bangalore South. My lord, for the reason that as per paragraph 5 of the order dated, my lord, 13/11/2024, my lord had directed us to file an affidavit as to the concrete action that would be taken for removal of encroachment. My lord, I am informed, my lord, that the action has been initiated. I have kept the special DC who is supposed to be passing the order
See,
present.
but if there is no proper coordination between BBMP and the government, see, the affidavit filed by them
Yes.
says that the complaint receiving authority is the jurisdictional Tahsildar. He has to conduct the inquiry and pass necessary orders. That's what it says.
Yes, my lords.
See, the moment a notice is issued under section 104 of Karnataka Land Revenue Act, the person who receives the notice will approach the High Court and will get a stay.
That's the problem.
See, the purpose is completely defeated.
This is based on the government order which has been issued. Necessary amendments will have to be carried out by the government to the order which is issued, my lords.
Yes, my lord, I don't have the amended copy, my lord. No, that is 2021 book. Or is there? 04.
The government, they say jurisdictional Tahsildar is the authorization to receive complaints, conduct inquiry.
So these have to be.
My lord, in this case, we have issued notice under section 67(2) of the Karnataka Land Revenue Act.
Something you are stating an affidavit is not backed by.
My lord, that is the BBMP's affidavit, my lord, but our proceedings are under section 67(2).
So that is issued by competent authority.
Yes.
Not passive.
No.
It is
No,
that.
My lord, that.
You produce and then we'll accordingly can mount the thing,
Yes.
direct them.
Very well.
You also need to change your action.
My lords?
You also need to amend your, what is your stated as action plan or what? Action plan for removal.
My lords?
Now amended, I don't know whether power is conferred.
There is a notice.
Where is the amended 104? Amended 104 is there.
Figures not transferable by virtue of any condition. That is the only amendment. 91, 98 on this. will be substituted.
This is an improper amendment.
This amendment, but if we look at 67(2), then Tahsildar is not the competent.
No, my lord, but in my case, my lord, we have the additional deputy commissioner confirms that the notice is issued under section 67(2).
May I just assist, my lords? Page 63, my lords. My lords, page 63. I think that answers my lordship's query, my lords. Page 63. Now the authority is now given to special DCs, my lords, as per the government order. It's
No,
at
you'll
page-
have to change your affidavit now.
Affidavit, I'll change the affidavit, my lords.
They are-
Affidavit,
Because
I-
the
I-
proceedings has to be initiated under
it is being-
67(2),
it is being
otherwise.
Yes.
And
I mentioned that in my affidavit as well.
Your
The
Lordship,
proceedings.
they had already given a report, Your Lordship. Survey has been conducted. We are, my make one submission. This honorable court appointed NERI, National Environmental Research Institute, and they submitted report on 24th May 2021. Thereafter, the 29th July, this honorable court passed a detailed order, noting where are the survey numbers which has been enclosed. And
Page 11 of my affidavit.
6 volumes are there before this court. They already identified with the help of the ADLR, Your Lordship. All the survey has been conducted.
No, that is not the.
Now the removal question is how it should be. That is the issue in what you are.
Answering the section
Which
67.
they are sleeping over for the past 3 years.
Page 11 of my affidavit, my lords.
And
My-
DC has
my
not
lords may
filed
kindly look
till
into
date the affidavit.
Page 11,
Response number
the
5.
last two lines.
13th November order is
I'll
not
finish my submission.
not been properly. Kindly, Your Lordship.
11.
13th November, Your Lordship.
In the meantime, the Office of the Deputy Commissioner Bangalore wired an urgent memo dated 16/12/2023, wherein the responsibility of conducting inquiry and passing of the order on the encroachments was shifted from the Tahsildar to the special DC. In the said letter, the DC has further directed the jurisdiction of Tahsildar and the ADLR to immediately identify and mark the encroachments and report to the special DC to enable the officers to pass orders on removal of encroachments. So right now, the orders will have to be passed not by the Tahsildar, by the special DC.
And in fact, Your Lordship, in August, I filed a memo. Just by encroaching the stormwater drain, Your Lordship, huge school building has been constructed. Survey report has been given in survey number 57, grid 33. This was brought to notice as early as in August 24. Till date, no huge building, how it can come, Your Lordship, that on the stormwater drain in RR Nagar. And they said they will look into it. Till date, no action. It is still lying there. A big building. Memo is also filed.
Notice and inquiry is held by special document.
By the deputy special deputy. But still to be precise, you need to change it.
My lords?
My lord?
That amendment to 104 is very vague. We can't comprehend what is that actually.
My lord, for that I can only write to the government and then intimate to
But
them.
we can proceed on the basis of 67.
7(2), my lord.
So I have to look into it. Your Lordship. I have to look into that amendment. Your Lord.
My lord, may I make one request, my lord? My lord may have this after 2 weeks, my lord. I'll produce the orders itself. Orders itself I'll produce. Because the special DC is before my lords. He's in the midst of the inquiry. My lord, they are present before my lord, so they know what is happening. And within 2 weeks,
No,
I'll see that.
67(2), you have jurisdiction.
No,
Yes, yes, yes.
67.
104, it is not.
That's what. 67 they have.
That's what.
In response to the order dated 13/11/24 passed by this court, wherein the respondents were inter alia required to come out with the joint plan for the purpose of removal of the encroachments on Vrishabhavati
Vrishabhavati.
River, respondent Brihad Bangalore Nagar Palika has filed affidavit pointing out that joint action plan is chalked out and the modalities thereof are also worked out. In the said affidavit filed on 22/11/24, from the said affidavit filed on 22/11/24, those who were noticed in course of the hearing of the petition that the complaint receiving authority and the order passing authority in the joint plan to be acted upon, is stated, is mentioned to be the jurisdictional Tehsildar, who will, as per the plan conditions, receive the complaints, conduct inquiry, and pass the orders regarding removal of encroachment. Full stop. Section regarding encroachment. Removal. Would at rest. Provisions of 67. 58 and 104. Karnataka Land Revenue Act. Summary eviction is provided. Summary eviction of the person unauthorizedly occupying the land is provided in section 104. Section 104 reads as under. Court 104. Similarly, section 67 reads as under. So 67 pura up to subsection 3. Full stop. Said sections underwent amendment by virtue of the Karnataka Land Revenue Integrated Third Amendment Act 2024. The amended section 67 the amendment in subsection 2 of section 67 introduces the group of words, including the assistant commissioner or a survey officer, not lower in the rank than the assistant commissioner. Four words. Instead of deputy commissioner, assistant. For the words, the deputy commissioner or a survey officer, not lower in rank than a deputy commissioner. So, since the power will be exercised for receiving complaint and taking action under section 67(2) of the Act, the competent authority would be the deputy commissioner or assistant. Would be the officer not lower than the rank of assistant commissioner. Full stop. In view of the above provision, when the stand of the BBMP is that the Tehsildar is the competent authority, it appears to be incorrect. Full stop. Learned advocate for the BBMP, Mr. Prashant.
Yes, ma'am.
Submitted that he would file further affidavit.
I've already clarified in the same affidavit, ma'am. I've clarified that position in the same affidavit at page 11 and 12. Page 11 and 12, I've clarified that it will now be passed by the special DCs.
However, clarified this aspect in paragraph.
Page 11, last paragraph, ma'am.
In paragraph. No numbers. Yes, in the following page
11.
11 in the
11,
meantime. We'll be able to find out page 11 of the episode. In the meantime, Two, encroachments. Full stop. Paragraph. Learned additional government advocates in the paragraph. Nilofer Akbar would submit with reference to the above aspect that he will produce the copies of the actual order received, which are by the Deputy Commissioner of the
Special
Assistant Commissioner. Produce on record the copies of the orders which are actually issued by the Assistant of the Deputy Commissioner. Full stop. Then we.
My lord
then
wants
we'll
me to,
dispose- After you produce, we'll dispose it of.
yes,
Yes.
my lord wants me to produce the notices issued under section 67(2). Yes, I'll produce.
Wait.
If my lord were to grant me 2 weeks' time, my lord, I'll see that the orders are also, my lord, produced, are passed and produced before my lord.
24th of
I'm obliged,
March to be listed at 2:30.
obliged.
We can dispose of now.
Yes, my lords.
And this encroachment, Your Lordship, is 92 wards identified by the NERI, 92 wards in Bangalore, Your BBMP
Whatever you want to
limits.
submit, you can submit, but now these things are coming to a logical end.
Yes, my lords.
Yes.
Right.
I'm obliged, my lord.
This is- Maybe. Yes.
Number 38, Mr. S.B. Mukanappa.
Petitioner. The petitioner is the senior citizen in the residential of Pillian Garden, Bangalore, my lord. My lord, the fourth respondent is the owner of the residential property bearing number 157, new number 48, second main, 6th class, Pillian Garden, first stage, Bangalore. The fourth respondent has, my lord, converted the portion of the residential house into commercial shop and running the beef stall in the shop without having any valid license from the respondent.
We'll respond.
The respondents, my lord, the BBMP.
BBM.
BBM.
Notice has gone or not?
No, notices served, my.
So who will have? Wait. No reply is filed. Reply shall. be
Monesh
filed.
Kumar, KB.
Reply is not filed.
None.
Although the petition, although this public interest petition belongs to the year 2022, no reply is filed so far, even after passage of 2 years by the respondent concerned. Full stop. Therefore, it is directed the reply shall be filed on or before 20th March. The petition shall be listed on 21st March. Full stop. Failing which, the petitioner will be entitled to seek on merits interim relief.
Much.
Number 39,
Petition will be entitled to seek interim relief by urging the case on merits.
39.
In this case, my lord, I am appearing for petition. Commissioner report, my lord, has been submitted before this court, but translation has not been done by the respondents, my lord, insofar as, my lord, sketches in Kannada
Give
and the report also in Kannada.
All right, translation to be provided, send out to 26th March.
ಇಲ್ಲ translation ಇಲ್ಲ ನನ್ಗೆ
Translation is available.
ಇಲ್ಲ translation ಕೊಟ್ಟು
11 portion I have
There
translated.
like,
I think you-
ಇದೆಲ್ಲ translation ಕೊಟ್ಟು ನಾನು ಕೊಟ್ಟಿದ್ದೆ.
on time,
No, my lord, they have said that they have produced the translation.
Translation
Kindly
is
see,
still
my lord.
before the court.
ಅದೊಂದು ಚೂರು ಕೊಟ್ಟು. Kindly see, my lord, sketch which is produced. Sketch which they have produced. That is, my lord, insofar as, my lord, the Sthala Mahajar is concerned.
what was the last order?
No, my lord, there was a joint survey, my lord.
Joint
There was-
survey,
We had sought
which is
liberty
directed
to
to
conduct
conduct.
joint survey along with the revenue department as well as the petitioners in the matter. Case of the petitioners, my lord, that there is a crematorium, my lord, that is overlapping over the area which was granted for mining lease. On last occasion, page 11, I had referred to, my lord, to say that the crematorium where crematorium is scheduled, my lord, that person is not a petitioner before the court. The petitioners before your court, my lord, there is no crematorium that is located insofar as their area is concerned. If your lordship look at page 11, my lord, of the survey report which I have placed before the court. It is dated 11th February.
Case is that there is a crematorium.
Crematorium, my lord,
That is
subsequently
which is
deputy commissioner
challenged,
has
my lord,
passed
after
an
grant of
order.
quarry lease, they have granted for crematorium after in the year of 2020, which is challenged before this court. Kindly see the sketch which they have prepared, which they have clearly stated in the sketch with a translation copy which they have not produced. I may permitted to read, my lord, last page. Pagination is also not there. The last page, my lord, this is the sketch which they have prepared. Pagination is not there, but this is the sketch which they have produced. Kindly see, here I may permitted to read. That is block number 1, 2, 3, 4. This is joint survey conducted. ಈ ಬಣ್ಣದಿಂದ ಗುರುಸಿದ ಜಾಗವು ಸ್ಮಶಾನದ ಜಾಗದೊಳಗೆ ಬ್ಲಾಕ್ ನಂಬರ್ 1ರ ಗಣಿಗಾರಿಕೆ ಓವರ್ಲ್ಯಾಪ್ ಆಗುತ್ತಿದ್ದು ಇಂಗ್ಲಿಷ್ ನಲ್ಲಿ
Translation.
First, my lord, kindly see translated copy. The place shown with color is overlapping upon quarry lease. Please, my lord.
The map is clear.
I'll draw your lordship sentence, page 14, translated copy, which, my lord, I can't conduct query list, that kindly see the merger also, merger which they have produced, and kindly see the translation copy of the merger. That is in page number 7. During the spot inspection, it is found that quarry activities of the quarry lease have been stopped at present in survey number 28 in the ambit of the said area, and details of the quarry lease area is a quarry lease number so and so 710 R1 has been granted to Somshekhar over extent of 20 guntas for a period of 20 years on 19/8/2010. The quarry lease 803 so and so granted in favor of Dattatreya Ganapati Vittalkar, and 809 has been granted to Nijamuddin Bennur. Further, in the ambit of said quarry lease, Deputy Commissioner has order on 28/9/2020 and 4/11/2020 specifically reserving 2 acres of each of the purpose of construction of solid liquid waste disposal unit by Gram Panchayat for general public and burial ground for general public. During the joint inspection, it was found that burial ground reserved for the general public and the restroom building have been identified inside the quarry lease area of 803, and the road leading to solid liquid waste disposal by Gram Panchayat is passing through quarry lease 809 and 810. There should not be a public structure, railway line, a reservoir road adjacent to the quarry lease area within distance from 200 meters. If yes, there is a restriction to usage blasting. All the above information has been, this is merger. Kindly come to, my lord, page, my lord, 30. For a moment, I'll draw your lordship's attention. This is blockwise, my lord, has been given. First block, my lord, kindly see translated copy. I'll read to convenient of his lordship. The place shown with the color is overlapping upon the quarry lease sketch of black one, and in this area 500 meter into 8 meter equal to 400 square meter, there is a burial ground building excluding the remaining area is vacant. It is extended is 31 guntas inside the quarry lease area. The restroom of the burial ground is situated over extent of 400 to into 500 meter.
You're only one petition.
3 petition, my lord. 3 quarry petition. 3 quarry lease. This all 3 blocks, my lord, is now road has been formed and wasted management has been done. My respectful submission is that this quarry lease has been granted. From 2019, my lord, it is granted. And Tahsildar, Deputy Commissioner, Forest Department, NOC is granted. No, my lord, if they are filing, my lord, affidavit before this honorable court, that I can do in as per the quarry lease, my lord, that there will not be a public interference and restriction. I may carry out because I have paid advance royalty, and, my lord, that they have granted subsequent to that during subsistence. And this overlapping is there that they have admitted in block number 1, 2, 3. That is kindly see, my lord. If they are permitting, there is kindly see restriction under section 6(2) also. If they are saying, my lord, that they are providing, otherwise I can't run.
Come to page number 11,
Page number 11, my lord.
the map.
Map, this is, yes, page number 11, yes.
Page number 11, not the master, the map.
Map, yes.
You got the map?
Yes, my lord.
2, 3, 4 is your quarry lease.
Yes, my lord.
There is no burial ground over there.
Kindly see
It
this.
is there in number 1.
Number 1.
Number 1.
Burial ground, but they have clearly stated that the road has been formed into the quarry list area. Therefore, my lord, this sketch is para 13 is, page 13 is very important, which is drawn by all the surveyors and my lord village, the village accountant.
13 is something over here.
No, this is my lord is insofar as block. ಎಷ್ಟೆಷ್ಟು ಎಂಟ್ರಿ ಆಗಿದೆ ಒಳಗಡೆ ಓವರ್ಲ್ಯಾಪ್ ಆಗಿದೆ ಅಂತ ತೋರಿಸಿದ್ದಾರೆ ಅದರಲ್ಲಿ. ಬ್ಲಾಕ್ ನಂಬರ್ 1, 2, 3 ಎಲ್ಲದಕ್ಕೂ ತೋರಿಸಿದ್ದಾರೆ. This is sketch has been prepared. This is block number 1, 4, 2, 3, 4, which is written, my lord, ಎಷ್ಟು overlap ಆಗಿದೆ ಅಂತ. How many extent which is overlapped. Therefore,
no, you are referring to this.
This one. This sketch which they have, all of them they have signed and stated that, my lord, there is an overlapping in all quarries area, block number 1, 2, 3. If I may permit to read that, your lordship will come to know. If at all, my lord, that they are, I could not run quarry activities if, my lord, as an authority, my lord, that they are permitting and they are permitting us to run the quarry list with the public. Since, my lord, all.
No, government. Please come to page number 13.
Overlapping number 3.
The third map.
Green.
Please.
It's showing overlapping over there.
Lord, in respect of block 2 and 3, my lord, there is a road that they say, my lord, there is road passing.
That he says that it can't be done.
20 ಗುಂಟೆ ಇರೋದು, 20
No,
ಗುಂಟೆ,
burial as
15
such,
ಗುಂಟೆ.
burial ground is in block 1. And so for us 2
See,
and 3,
your
they say that
contention
there is a
was-
road that is coming up.
See, your contention is there is no overlapping. His contention is where he has been granted the quarry lease, there is overlapping. That is his contention. Now you need to answer that.
If at all they are allotting alternative, we have no issue. Otherwise, if they are protecting, we have no issue. We are not before this court because, subsequent to that, they have troubled us.
You have to get a clarification for
I'll
this.
get the clarification, my lord.
Green.
Because in,
Green portion is overlap.
please, my lord, I'll get a clarification because they say it's marked as road, my lord, but there is no quarrying activity. I'll take instructions, my lord, proper instructions on this. It's a road portion where no quarrying activity is being carried out. That is what they say. My lord, in any case, Deputy Commissioner's order, my lord, was subsequent, my lord. Lease was granted earlier. They could have submitted a representation, my lord, whereby.
We have
the crematory
representation,
could have
several
been moved elsewhere.
representation.
One possibility.
See, when you grant the land for burial ground, you should take care of these aspects.
No, I'll secure instructions. my lord. So far as the road part in block number 2 and 3.
Mr. HSRD wants to file a clarificatory affidavit in furtherance of affidavit dated 11/2/25 to suggest that there is no overlapping of burial land for this query.
My lord, now, so
Burial.
far as burial land is concerned, it is in block 1, my lord. So only in relation to block 2 and 3, where they say that there is road.
Clarificatory affidavit to the affidavit so and so. And shall if you second appraisal.
Great, please.
This is number 40.
My lord, kindly post this matter for next week, my lord. Kindly post this matter for next week, my lord. My senior is not available.
Which one? What is that?
40. Serial number 40.
What is it about?
My lord,
What is the subject matter?
Certain lands have been acquired for the benefit of Metro and the National Highway Authority. The contention is this land is a government land. There is no grant. Still compensation paid to some private parties. They have seeking, holding an inquiry. That's how they brought in Union of India as well as NHA and state government as parties. This is the interest.
It is already acquired.
So far as.
Land has been acquired, some
No,
portions.
so far as NHA is concerned, my lord, they are saying that 80 acres of land has been acquired, but that is not the correct statement. They themselves have produced the award, which shows it's a 9 acre of land has been acquired and total extent in that survey number was 80 acres. So it is not that 80 acres have been acquired. It's 9 acres have been acquired and compensation has been disbursed based on the documents produced by the landowners. And they say 55 crore has been paid to respond number 7 to 11. But there are about 28 people to whom it has been paid total amount. So it's mean there are so many false statements have been made. And whenever NHI disburse the compensation,
For National Highway,
I appear for National Highway Authority of India.
find some 2-page affidavit.
Please.
That's all.
Yes.
Nothing more. You are not telling, it is already acquired, madam.
Already acquired and it is on this airport road where toll booths are there. So it's like huge extent of land has been acquired and used for, so it is utilized also.
It is not a land challenge to land acquisition.
My lord, pass over, my lord, pass over, my lord.
Pardon?
Pass over, otherwise.
Pass over.
My lord, we will file our objections, my lord. I am the respondent number 8. We'll file my objection.
Who is number 8?
Private party.
The allegation is not, this is a government.
2-page affidavit.
Please, your lordship.
About the details of acquisition. That's all.
Will file.
And portion
It
of
of
the land is
notification.
acquired for Metro, even we will file our reply.
File it.
Please.
So on 25th March,
Please,
Please, your lordship.
before that you file so that we will dispose upon that. Day.
Please,
There is
please.
nothing as such.
Please, your
Yes.
oblige.
Number 41 to Bal Gangadhar GS.
For respondent number
But in
3 and
these two
4,
matters, my lord, actual submission is this, my lord, in the contempt proceedings, direction by the division bench, my lord, to pay the salary arrears, everything, my lord, has not been complied with. My lord, on that day, my lord, when the matter was taken up, they filed an application and affidavit and undertaking that, my lord, they are going to comply. My lord, kindly appreciate, my lord, in the affidavit, there is no compliance at all, my lord. Instead, they have commented upon the orders of the honorable court. And therefore, my lord, I have filed IA, my lord, because liberty was given to me to file necessary application or to revoke the contempt proceedings. The affidavit is totally, my lord, there is no compliance at all, my lord.
Let us go to the directions. Page
Please.
38.
Please. Please, my lord. 38 is, my lord. That's the direction. To pay, my lord, pay scale and other allowances, emoluments and benefits. They undertook to comply, my lord.
Read it.
Please.
There
Be
is
there.
14, needless to mention that.
Please, that if the appellant's official respondents desire to conduct training for the respondent number 4, they are at liberty to do so within a period of 6 months from the date of receipt of certified copy of this order. If no such training is conducted within the time mentioned above, then the appellant's official respondent shall do whatever that is required to restore the pay scale allowances, emoluments of respondent number 4 as mentioned above, and pay all arrears within a period of 9 months from the date of receipt of certified copy of this order. Respondent number 4 is at liberty to furnish a certified copy. This is...
Training is held?
No, my lord.
Not held.
Not held, my lord. My lord, they filed the affidavit. Kindly, my lord, peruse the affidavit. I am really shocked, my lord. Page number 20 of the affidavit may kindly be perused, my lord. Please, my lord. Page number 10, para number 20, my lord. This is what they supplied me subsequently. Please, my lord. They say it's sworn to them, my lord. I further states that the division bench in writ appeal number 121 of 21 neglected that the single bench has still contemplated the need of training and kept the opportunity to conduct the same to complete the training of the components and promulgating the quashing of the endorsement. Now, my lord, in para 23, they say so many things. My lord, that is not at all necessary, my lord. Page 10, my lord. Page 10, para 20. Instead of complying, explanation is given, my lord. My humble submission, my lord, it requires recalling of the order. Kindly, my lord.
You drafted the affidavit? Who drafted it then?
How can you draft this paragraph 20?
No, who drafted it? An advocate drafted it or? See, one thing you people should remember, even you, Mr. Raghavendra, you people are first officers of the court. Don't act like agents or spokesperson of your clients. You should be in a position to guide your clients so that justice will happen. More so when you are appearing for the government.
Who is the deponent? Let us see.
Please. Abdul Rahman, my lord. Accused number 3.
Principal Hazrat Shah
Please.
ITC and Training.
Pardon, your lordships.
So you do take your call.
Your lordships, the thing is, the RP was dismissed over here, and with regards to that, an SLP is pending.
That is not the question. What is filed and what is not filed, and who has succeeded, who has not succeeded. We are on the averment is really
I'll seek instructions, your lordships.
no instruction. Now, what is the reply to contempt petition? There is no reply in this contempt.
Please.
Not only not there is no reply, there is a very, to say the least, the offensive,
Please.
very offensive approach to the court. And the counsel is rightly saying it is commenting on the court, commenting on the order of the division bench. What is this? High Court was abortive to understand. We all up for contempt now.
Your lordships, I will verify the same, your lordships. One opportunity.
What
will
are
be
you saying?
given.
High Court was abortive to the abortive to understand that the respondent is working for the applicant for. We are abortive to understand. What kind of insinuation you are passing?
I'll verify who it was done by.
You verified twice.
Yes, your lordship.
We don't upon your verification. Single judge of the court has failed to acknowledge the fact that the respondent is already initiated admission. Then also comment on division bench. Division bench in writ appeal number so and so 120-21 neglected the single bench, has still contemplated the thing. What's your name?
Safrina, your lordships.
You have drafted the affidavit?
No, your lordships.
We still believe that you have drafted it, therefore we are mild in reacting. You are Siddika Aisha?
No, your lordships.
No. present contempt petition is filed, seeking compliance of the directions of the order passed by the division bench on 12th July, no, where is it? 12th July. 12th
Please,
July?
please.
12th July
21.
2021. Which reads as under, then quote paragraph 14 of the order at page 38 and 39. Bracketed portion. It was submitted that respondent is required to restore the pay scale, public allowances, public emoluments within stipulated time as directed by the division bench. The affidavit on response came to be filed by one, affirmed by one, Sri Abdul Rahman, son of Abdul Karim, stated to be the holding the post of principal, Hazrat Madar Shah, ITC, and D.Ed, D full stop Ed, Training Center, Ashoka Road, Tumkur, 572102. Instead of answering about the compliance of the directions which are subject matter of jurisdiction of the court under the Contempt of Courts Act 1971, the deponent has proceeded to narrate the details in somewhat offensive way. Which amount to calling in question. Indirectly calling in question the order and the directions passed by the court. Not only that, following averments were noticed, which are not only highly objectionable, but appears to be contumacious, CONTUMACIOUS. In paragraph 15, it was stated thus. So, quote paragraph 15, page 8 of the affidavit. I further state that the High Court was abortive to understand In paragraph 16, it was stated that learned single judge was a failure in acknowledging fact. So quote paragraph 16, only bracketed portion. What is this? Who has drafted this? Will be in difficulty, landing in difficulty. Every sentence we read, it's entire paragraph 16. Once again, there is a offensive remark in respect of the order of learned single judge without filing any appeal. So quote paragraph 70. You are in difficulty, madam. Your client is in very serious difficulty. Unless you call a thing, you are not understanding with what you are suggesting. Yes. Not only that, after quoting paragraph 17. In respect of the order of the division bench in writ appeal number 121 of 22, the following comment is made. Paragraph 20. When you have the above statements and the compliance affidavit made, the court directs the said deponent names Abdul Rahman, whatever. Abdul Rahman, son of Abdul Karim, Principal Hazrat Madarsa ITC and DA Training Center, Asokara, Tumsel, to remain personally present before the court on which date?
Are you understanding the consequences? Have you read the affidavit?
Since how many years you are practicing?
Last year, it's
Last
2024.
2024, since 2024. So you just understand the implications of your affidavit and then take a call. Tomorrow we are keeping, instead of passing this order finally. You take suggestions and take guidance from some senior member of the bar whom you know. Show the affidavit to her, to him, and take your own decision.
Please.
Today is what date? Keep it on Friday.
7.
Friday.
Well, both the matters.
She is young and not.
Please, please, well, I understood.
Signed it, sir. That also she should say. Who is the advocate who has signed the?
Advocate, senior,
The advocate who has signed the affidavit, who has signed it?
I'll have to check, sir. The copies I have do not have the signature.
Then it name is mentioned.
But for one Siddhika Aisha is.
We don't want to become unnecessarily harsh and damaging. If this is to be taken to logical end, Not only the deponent, but the advocate will also, serious voters. So you take your tips from some senior advocate and then come back on Friday. Friday or Monday when?
Friday better, my lord. Monday some inconvenience for me.
Friday?
Please. 42 is also similar.
Type of the order, then skip the.
But 42 is also same matter. Similar affidavit is fine. Please, ma'am.
What's your name?
Safrina Begum.
Very well.
Machu.
Serial number 44, my lord, that I have produced, filed IA, which is, my lord, that they have said, my lord, it is not received by them. Copy of that.
Need
And
some-
I have served, but once again, I will send.
When do you want?
I
Oh,
know.
Third,
Any date, my lord.
4th April.
4th, much. Serial number 44.
Yes. Same matter. So anything?
Member 90.
I appear for the respondent in this matter, my lords. Lords, I was supposed to furnish the name of the architect, my lords, for
Survey.
carrying out the inspection and the assessment. I have proposed the name of an impaneled engineer in the arbitration and center, my lords, Bangalore. So I have proposed, I've also served a copy on them.
That's, my instructions are, we would also like to have one of our own engineers to do the survey along with them. Let two of them do it in coordination with each other or otherwise. It can be a joint survey. Lords, he is the head of the Civil Structures Department in the Indian Institute of Science. Lords, the reservation is however only on one aspect, my lords. The reservation may be, had expressed this even before the commercial court. We have no difficulties in an independent surveyor, even if suggested only by them also, to carry out the measurement of the quantities of the exact work which are done. Since it is an incomplete civil construction, the value of the construction to be ascribed would be a subject matter of evidence to be led and for the arbitrator to decide. If he wants a valuation to be fixed under the joint memo, then it removes my right to challenge that valuation before the arbitrator, because they will say, affix the signature to the valuation. To the extent of quantities, let it be fixed. There is no difficulty. To the extent of valuation, that is a subject matter of appreciation of evidence. I can give my own valuation relating to the approval of the contract.
If I may submit.
You have no objection with regard to the name suggested by him
I have no objection, my lord.
with regard to quantities?
Yes, my lord, with regard to quantities.
Yes.
Second submission I would like to make, my lords.
If I may.
Once
if I may
the,
submit so far as this.
One second, after him you submit.
I am the appellant of all. My lords, if the date can be fixed, my lords, and the measurements can be completed.
Yeah, it's an arbitration.
Valuation may be arbitrary.
Yes, my lords. Valuation is to be the subject matter of arbitration.
Milad,
That is something which I cannot ascribe to in writing in terms of confirmation of values. My second submission, once a date is fixed and provided we complete on that day, the interim order will cease to operate from that day, my lords. My construction has stopped for almost more than a year. He quantifies the value of the extent of damages already. For some reason, he insisted, my lords, though it was not put in writing before the commercial court. This was a submission made that he needs to get the assessment of the work done. The entire quantification was done. He values the extent of work done, issues a notice, and then he comes before the arbitral tribunal, my lords, before the commercial court, in a petition under section 9 and makes a statement that I should not carry out further construction. That kind of injunction does not lie in his hands to ask. Post the measurement, whatever may have been the merits of his case, post the measurement, I should be permitted and this order should go. That's all is my submission.
If I may submit. In fact, we have also wanted a measurement, but the proposal that they gave was, we did not have the name of the person. 2 days notice was given. And then we had lost trust in them. In fact, we gave a reply indicating all these aspects. My humble submission is this, the valuation that I've indicated is in line with the arbitration agreement. The agreement clearly indicates the quantities and proportionate amount also. In fact, my humble submission is, it would be well within the realm of the court commissioner to do the job. If he finds it not possible, he may indicate it so. So my humble submission, no, Milad, my humble submission, the contract may kindly be looked at, Milad. I have furnished the.
No, counsel.
Milad.
Cost involved becomes an arbitrable dispute. Okay. He has no objection for measuring the quantity of work executed. Cost is a fluctuating thing. He can record, this is the material put, and this is the area constructed, this is the foundation dug, this is the area constructed in ground floor, this is the area constructed in first floor,
yes,
second floor, whether electrical wiring has happened or not. that can be recorded.
No, we have not even finished the foundation. We are just
Not
at
yet
the stage
finished
of
the foundation,
excavation,
sir.
just the foundation.
The
So
pile
if they
foundation
want
and
to
the
know
retake-
quantities of cements that may have been used for completing such a work, because it cannot be broken to ascertain, if they want an assessment of the amount of steel that may be used for this, all that can be done. What is the extent of work done? What are the quantities of cement, steel which may be required and sand for this? Since it is an incomplete work, I would have given values for a completed wall. He has completed half a wall. Do I take that as a benchmark or do I take actuals as a benchmark?
And you can
Is
have
an
a
arbitrable
videography
issue.
also done with regard to the building and the construction that has happened so far.
Portion of a foundation is constructed.
That's fine.
That's
He's agreeable for quantity of work to be done. I mean, that has been recording the quantity of work done. I think that should take care of your interest.
My humble
So
submission
the
is-
cost, we can bring in the expert and he can lead the evidence before the arbitrator.
yes, should be fine.
Because it's not binding. It's not something that is binding on anybody.
quantities is binding on me, my lords. We are no challenges
With regard to
quantity.
cost, it is not binding.
Quantity and the complete extent of completion of work, the
Exactly.
percentage of work. Yes,
For that, he is agreeable.
yes. And my humble submission is, my lords, the date may be fixed where the report may be submitted before this court and subsequently the order may be vacated.
No.
No, my humble
Once the
submission is this.
report is finished, it will be submitted as a part of an arbitration claim.
My
The
lords,
arbitrator will have to consider it. The
Because
question
the
of
CMP is pending
preventing
for the
me,
last more than 1 year, my lords. Prior to filing of this AA, my lords, they have not bothered to appear, my lords. My humble submission is this. In fact, they may be directed to take notice in the CMP and appear there. My humble submission is this. Let the report be filed before this court and then it may be vacated.
that is a piece of evidence to be considered by the arbitrator.
My lords,
Today, any interim order is operated.
there is an interim order passed by the,
That may see that at the end of at the time when the.
on the filing of the report, my lords, my humble submission is this.
Either of the right party can file section 17.
My lords,
Yes.
the arbitrator is yet to be appointed, my lords. They are not cooperating in the appointment of the arbitrator. Even
No.
prior to this application, they
May
are not appearing there, my lords.
May
before
I,
this
may I, may I
report,
just,
my lords.
may I just clarify?
The notice
my
is being
lords?
avoided.
Any consensus about the name of the.
Yes, my lords, we are ready, my lords. Your lordships may propose, my lords.
May I just, my lords, make one submission? My lords, may I just make one submission? The petition under section 9 the petition under section,
Further construction may be subject to the arbitral.
no. My lords, he doesn't claim an ownership. He's a contractor of the property.
Absolutely.
He is
I'm a
not the
contractor.
owner. The
Premature termination
petition
of the
under
contract,
section
my lords.
9, I have terminated, my lords. If
Prematurely
there is a
terminated.
cost and risk to it, I have to suffer the cost and risk to it.
The damages were.
He has quantified the damages.
I'm entitled
The
for damages.
petition-
My humble
I
submission is,
understand.
he is trying to engage another contractor and carry on with the construction. I would lose my evidence that is there. My lords, I was thrown out.
For that we are submitting, let there be a measurement done, quantities are ascertained. He doesn't claim a property to be owned by him.
Of the surveyor or inspector, the evidence will be preserved.
That's all. Then thereafter, this injunction
humble-
to prevent me from enjoying my property may not survive.
So my humble submission is, a date may be fixed and the matter may be listed 2 weeks hence, my lords. 2 weeks hence, this matter may be listed. A
No.
No, my lords, my humble submission is this. The court commissioner may be appointed. His report may be submitted and then the order may be. my humble
Lords, I
submission
will
is
give
this.
an undertaking to the court that we will not put up construction until the survey is conducted.
Fair.
After that, once it is done, I am agreeing to his surveyor. I don't even want to suggest a different surveyor. Reservation was only on valuation. His valuation will be a subject matter which the arbitrator will have to decide. I will have to enjoy my property. My lords, his right in the property is not
I have
claimed.
no objection is in his enjoyment. My only objection is in his destroying the evidence that I have not collected after having done the work that I have carried out.
Once the surveyor surveys the entire thing and records the quantity of work done,
My only humble submission is, my lords, for some reason, something is left out or some aspect is to be considered. A short date, 2 weeks may be granted.
No.
no, sir, he is agreeing for your surveyor.
That
And your surveyor only is going to be,
not, he's an independent surveyor, my lords. In fact, we
Fine.
got the name from the arbitration center, my lords.
This exercise we are doing not to keep the petition pending.
May I request? Milords, 2 weeks. In fact, let him, Milords, even he need not submit the report, maybe kept pending. Milords, it may be disposed of subsequent. Milords, my only concern is that the survey report has to go on, Milords, and then my only apprehension is something happens. Your Lordships may dispose it off, and in case he does something, the entire thing will.
After the completion of the survey and receipt of the copy of the survey report only, he will be permitted to go on with the construction, not before that.
I leave it to Lordships. My interest may be protected, that's all.
His interest is to be adjudicated.
And an arbitrator. And the
That
arbitrator.
that in the CMP will make our submissions, my lords.
Okay. Give the name of the survey.
Milords, Mr. Chetan Kumar R. Milords.
With address, everything.
Milords,
Yes,
in
ma'am.
fact,
Put it there.
we have provided his profile, Milords,
Annexure
at
A.
Annexure A, Milords.
When do you want the survey to be conducted?
Any day. Milords.
Any day, Milords.
Give a date of your choice.
This Sunday is also convenient for us, my lords.
Milords, we would,
Because we are going to fix the date also.
Please, my lords.
subject to his availability, Milords, after 15th March, any day, Milords. Milords.
1.5 years, my building is lying vacant.
It's all right, it all happens.
True, my lords.
In the present circumstances in a city like Bangalore, these are common things.
Milords, may I
So
request
if
on
you don't,
17th,
as less properties as,
Allah, let it be a,
17th, Milords, 17th.
not a weekday, let it be non-week. Any Saturday, Sunday, my lords, to the convenience.
Give a
Because
convenient
councils
date.
also may be present and clients also need to be present.
22nd.
27th High Court working day, 15th of March, I think should be okay.
I'm
15th
we
and
are fine.
16th of March. my lords.
16th happens to be a Sunday, if that is fine.
Yes, yes.
16th.
Yes,
16th is Sunday, Milords, I think that would be convenient. Milords, may I also request an arbitrator to be appointed, Milords?
No, that under section 11, my lords.
They
we
may be
have some-
directed to appear, Milords, they're not appearing.
That's a separate proceedings.
That's
We
a
are not
separate
concerned
proceeding.
about.
least
I'll
The
submit
direction
there,
may
my
be given,
lords.
Milords, there are same address we are surveying, Milords. Prior to filing of this application, Milords, the CMP was filed, Milords. They are not appearing, Milords. Same address, Milords, gets returned, Milords. They may be directed to at least appear, Milords.
We can't monitor those proceedings by making any observation.
Milords, same subject matter, Milords, same thing, Milords. My humble submission is,
The council makes a statement, then we can record
Lords,
it, not our direction.
We have not entered appearance in those proceedings, my lords. I have no instructions. We'll find out, my lords.
Milords,
We will appear in those proceedings, my lords. I'm sure should happen.
Yes, we are passing the order. Sri Chetan Kumar R is hereby appointed as a surveyor to survey the details of construction made on the appeal schedule property. The said survey will be conducted on 16/3/2025 and all the details pertaining to the construction, that is quality of work done, shall be recorded.
Quantity.
Quantity of the work done shall be recorded. A copy of the same shall be provided to both the parties. After completion of the survey and receipt of the copy of the survey report by the parties concerned, appellant shall be at liberty to put up further construction on the property. If required, videography of the property showing the details will also be conducted. Order passed in commercial application 228 of 2024 stands modified accordingly. Appeal is disposed of.
Great.
Milords, I have also filed a memo of instructions. That may also kindly be noted.
You give it to the commissioner.
We've already filed, I'll also furnish.
Of
give it to the
instructions
commissioner.
Now filed has valuation also. So without that, let him file over there. Great.
Much obliged. Milords, an undertaking that, he's given an undertaking that he would appear before the CMP. That keeps going on, Milords. More than a year, Milords.
Arbitrator is appointed, is it?
No, Milords, CMP is
Lords, I
pending,
will
Milords.
undertake, my lords, till the survey is carried out, we will not put up any construction.
Not that, he wants wants an undertaking that he will appear in CMP.
CMP. Which
No,
is
no,
pending
no,
before
that
this
may
very
not-
honorable court, my lords. CMP number
That may
265.
not be.
In my application, commercial court, I filed I brought out that this commercial CMP is pending, my lords. The case number, all details are given, my
My
lords.
lords, I'll only submit this, my lords. We need to have some instructions vis-a-vis the name of the arbitrator otherwise.
My lords,
We'll appear in those proceedings, my lords. Let an order be made in those proceedings.
So that first statement you can make. You'll appear in the.
We'll appear in those proceedings, my lords. We'll engage that court relating to that subject matter.
My lords, CMP number 265 of 2024.
CMP number?
265 of 2024. my lords.
On next date of hearing.
Please, my lords.
Or recorded your undertaking.
Please.
Yes.
Great.
Grateful. my lords.
Till number 89. Mr. Sundar Raman, MB.
In this case, my lords. Matter has been listed for final hearing today. A date may be fixed where led by senior counsel in this matter.
For the caveator, my lord. Request for a short pause over.
My
Request for a
lords, a
short
date may be fixed in this matter. The matter can be taken up on another date, my lords, where led by senior counsel Mr. Dhyan Chinappa in this matter. The caveators have already filed their objections and also an IA to vacate stay in this matter, my lords.
Are you not aware about this order of the Supreme Court?
My lords, we are aware of this.
Then?
My lords, my lords, they've also made this submission before. the
Liberty is
Supreme Court,
reserved in
my
our
lords.
favor. Liberty is reserved in our favor to prefer a application for
No,
vacating
no,
stay.
that is not the question.
My lords, they've also made a
You are supposed to
submission
argue.
before the Supreme Court, my lords, that they were not served with papers, which is not the case at all because they were on
Whatever
caveat.
it is now we have got the direction from the Supreme Court to proceed with the matter, and you are not proceeding.
My lords,
I request for a short pause over.
my lords, if it can be taken up tomorrow or day after also, my lords, we are ready. The only inconvenience is that we are led by senior counsel is who is at his feet in another court. my lords.
Respondent 3, Your Lordship. Kindly pass over, Your Lordship, senior will pick up.
Notices are served to all.
Your Lordship, we have served the notice for the appellant as well as the government, Your Lordship. We did not know who has put wakalat, so we didn't.
No, all respondents are served.
We have the copies right now. Sir, I'm hearing on behalf of respondent.
My lords, we have filed a memo dated 3/2/2025, my lords, wherein we have taken steps as against all the respondents in this matter.
Why you are not taking steps?
My lords, we have already taken steps, my lords. In fact, the endorsement with the steps has been reflected in a memo that I filed dated 3/2/2025.
What is the memo?
My lords, it is the process that I've paid insofar as all the respondents are concerned. That has been filed before court as well.
What is that memo? 1678 of 2024.
3/2/2025, my lords, steps have been taken. It's on a presentation form with the
Read appeal number
annexure,
1678 of 2024. Okay. One, two. And who is deceased? Well, this one. Who is deceased? This appeal was admitted by order dated 16/12/24. Interim order was passed. And it was directed that the appeal shall be posted for final hearing on 5/3/25, which is today. It was pointed out paragraph that against the aforesaid order dated 16/12/24, respondent number who went to the apex court?
Respondent number
myself.
three.
Number,
I went
respond
to the
number,
Respondent number.
I
respond,
went to the apex court because there was an interim order.
respond number,
Respond number three,
which respondent?
number three.
Respondent three filed special leave to appeal number 2472 of 2025, which was disposed of by order dated 31/1/25 by the Supreme Court. Post of the relevant part of the order. Did says and we are not inclined to select the High Court. In light of the above order of the Supreme Court, Honorable Supreme Court, the appeal was called out for taking it up for final hearing. However, learned advocates for the both the sides wanted time to submit that appropriate.
I'll argue the matter is posted for final hearing. If matter could be taken up, we can dispose of the matter. This matter is specially posted for final hearing.
No, but they both are seeking time or not? They are seeking time.
I understand that. As far as I am concerned, I am ready.
Pardon?
As far as I am concerned, I am ready to argue the matter.
So learned, yes, what do you say?
We are led by Senior Counsel Mr. Gyanchanappa on this matter, my lords. We just need time because his presence is.
Learned advocate Ms. So-and-so appearing for the appellant stated that the senior counsel who is to conduct the matter is not available.
Not today, my lords. Any other.
He
day.
requested the hearing to be fixed on any other date. Full stop. At the same time, it was noticed from the endorsement of the board that respondent number 1, 2, 4, and 5 are yet to be served by the appellant. Respondent 12 who was sent with the notice of the court. But the envelope containing the notices has returned with endorsement that the addressee has expired. Full stop. In wake of the facts obtaining as above paragraph. Appellant it is incumbent of the appellant to take immediate steps to serve the unserved respondent number 1245 and respondent 12. Full stop. And to bring on record the legal heirs of the deceased respondent 12. For this purpose, time is granted. For this purpose, in the above view, the appeal is required in the above view of the request. In view of in the above view, in light of the above request from the appellant, as well as having regard to the status of service on the respondents, the appeal shall be next posted when?
Any date, my lord.
Tell your date so that they can.
No, because they are ready to comply certain directions. Because, so let them finish it and within a week's time, we will also have it on 8 or
They give 10 days. 10 days time? 10 days time.
I should like.
Full stop. Really. On today is what date? 5th. 17th or 18th? 17th.
May the interim order be extended?
On 17th. Before the next date, necessary steps shall be taken by.
May the interim order granted earlier be extended?
In fact, it was agreed by grant of interim order itself. So, when they seek time and seeking extension.
Not limited. It is not limited, so no need to extend. But we will have to proceed with the matter because of the direction. All of us.
For power is filed for R26.
Number 91, Mr. Satish K.
Here for the complaint. Lord,
in this matter, my lord.
the state's RSA was dismissed on, my lord, 19/6/2023. Thereafter, my lord, I have preferred writ petition, my lord. Learned single judge, my lord, allowed the writ petition. May I request my lords to kindly take, my lord, page 22. Operative portion is at page 22. Writ petition is allowed. Respondent number 4 to 6 are hereby directed to give effect to the decree passed in RA number so and so and confirmed by this court in RSA number so and so. This exercise shall be accomplished by the respondent number 4 to 6 within a period of 6 weeks from the date of receipt. And this was passed on 21/8/2024. 6 weeks time also expired, my lord, on 7/10/2024, my lord. Till date, they are not executed. Effected the, my lord, mutation in favor of the complainants. Last occasion, my lord, a submission was made that SLP is filed. Therefore, my lord, they took 6 weeks, my lord, almost 2 months time.
Where is that order?
The state has filed preferred SLP, my lords. The matter is listed tomorrow, my lords.
Tomorrow it listed.
It is tomorrow, my lords.
Before Supreme Court.
Miss, my lords. This is the.
Right.
Lord, it is not listed
Traditional
tomorrow, my lord.
The tentative date is 7/3/25 shown, my lords.
It is filed.
Lord, one submission.
482 of 2025, bracket over, which is going to be listed tomorrow for
La-
hearing.
Lord, may I make one submission? Lord, it is not listed tomorrow, Lord.
My lords, on 27/1/2025, my lords, the Honorable Supreme Court has granted time to file better affidavit for pertinent condition of delay, my lords. For on period of list after 4 weeks, my lords, the tentative date is shown as 7/3/2025 in
In with the tentative date is given to be
Lord,
7/3/2025.
that is changed to 21/3/2025. Lord,
And with the tentative date is given to be 7/3/2025
kindly see the, Lord,
for listing. What is this? 21/3/25. In that view.
Lord,
to-
similar request was made, my lord, last occasion. Subject to result of the SLP, my lord, let them change.
That view, the contempt petition may be posted on 28th of March.
Lord,
2nd April. When they have filed SLP and it's pending.
similar request was made, my lord. And my lord, when it was listed, your lordship may see the order sheet, my lord. At their request, my lord, SLP got adjourned. Your lordship may see the order sheet also. It is on their request, it was adjourned. To file a better affidavit, my lord, it was adjourned.
That is what I have placed it before my lordship. My lords.
That order was there in.
That I have placed it. Your
It's already there. Yes.
Number 92, Mr. Nagendra M.
28.
Mr. Nagendra M. 92.
Let it go. What is the contempt? Writ petition, PI. None is present for the petitioner, stand over to for separation.
It's a passover matters, still number 3. Mr. Prabhu Tumbigi.
Complete my lordship. I would like to bring few minutes. I am the farmer, my lordship. I requested to stopping the water forming, streaming water, my lordship. I gave a representation on that. In spite of page number 9, this order was the Honorable Court has directed the respondent to consider my representation and removal of obstruction of in the stream water, because I'm trapping coffee trees and pepper. I have no other business to do that. Entire my land has damaged completely. We are not giving it times to 1 or day, 2 days. Once it is.
Which order is not complied with?
Page number 9.
On 9, read it.
Can I? Meanwhile, respondent number 6 is consider the representation of the petitioner for removal of the obstruction in the stream following between the petitioner land and the that of the private respondent land of his. That is the question.
So you served this order on the other side?
Yes, I'm.
When? Where is the environment that you served the order? You served the order on the authorities?
Yes, my lordship. I served the order on 26/11/24, my lordship.
Where is that? How do you find it? And when the main petition is coming up?
Sorry, my lordship.
Main petition is coming up when? Before learn a single judge?
Is not yet listed, my lordship. Is not yet listed. But at least they are not considering at least to order of this honorable court, at least my representation.
You go before learn a single judge and make a grievance.
Because it's a serious cropping, damaging entire my land, my lordship. They are not at least, I have no other alternative things to do. It is very
While
sensational
so
things, my
this
lordship.
contempt petition is filed in respect of order dated 15th October 24, passed by learned single judge in the pending writ petition number 27474.
They themselves are also admitted there is a
Read judge
water
under
streaming in
here,
my land.
Page 9, full stop. Evidently, paragraph, the aforesaid order is interim order. The main proceedings of the petition are pending at large to be considered on merits, full stop. The interim direction is given by learned single judge to consider the representation of the petitioner for removal of the obstruction in the stream flowing between the land of the petitioner and the land of the private respondent. Full stop. When the main proceedings are still under consideration and the rights of the parties are not finally crystallized, the court is not inclined to exercise jurisdiction under the Contempt of Courts Act 1971. In that view, paragraph, without expressing any opinion on merits, leaving the petitioner to work out his rights and remedies in the proceedings of writ petition before learned single judge, this contempt petition is not entertained and stands disposed of accordingly. Yes.
Seal number 18, the Ganpati Bhatt.
This case, my lord, for petitioner. This is, my lord, second round of petition, my lord, that we have made an application for a grant of queries which has been rejected in the year of 2017. Then we have approached this honorable court seeking quashing of the endorsement at page number 17 annexure B. This honorable court was pleased to direct the respondent to consider my application and pass appropriate order. Order is, my lord, is at page number 19, para 3. Para 4. Therefore, the endorsement dated 29th August 2017 is set aside. We direct Chairman Task Force Committee, that is Deputy Commissioner, to convey the meeting opinion further directed the Director Commissioner Department of Mines and
So
Geology
page 28, it is given to you.
Please, my lord.
As per page 28.
Please,
the
my lord.
query is given to you on condition of obtaining no objection from the Forest Department.
No, my lord. That is, Office of the Assistant Commissioner Madhugiri has given no objection, saying that they have no objection to grant query lease. Assistant Commissioner Revenue Department.
No.
Okay, this is an NOC which is obtained by
Page 26 is the subject matter.
page 26 is the NOC which is given by Assistant Commissioner to the Deputy Commissioner, saying that this query lease can be granted.
Then what happened?
That includes nothing has been happened. Therefore, I have sought, my lord, they have written a letter to the Forest Department also. They have not.
That is the thing. Forest Department is not granted.
Not granted.
So that is
Till,
the
no, till not granted. They have said, my lord, kindly see, Forest, they have written letter but not considered. Let them consider in accordance with law and pass appropriate order within time frame period. That's all, madam, my respect.
Along with that, there should be a demand and refusal. What they have given is the application.
Annexer is there.
My lord, the order of the coordinate bench.
What is annexer? DE.
B.
EE, page 34. Hence the sketch is not included.
That is a letter written by the director to the deputy conservation.
The internal correspondence. Internal
22nd April to 22nd September 2018.
22. One annexure E in page number 34 is, my lord, 1/10/2022 that they have written letter to the Forest Department.
Madam, you go to page 34. The internal correspondence.
Page 35.
34 or 35 both.
My lord, this is on behalf of the deputy commissioner, my lord.
To the
Yes,
conservator
this
of
is given.
forest.
Now, this I have to verify, but it's because it says on behalf of the deputy commissioner, my lord may cease. Yours faithfully signed on behalf of the deputy commissioner, Tumkur district.
That is, Deputy Commissioner has written letter to the conservator.
wants to
second.
shy away from writing a letter to the deputy conservator of forest.
Forest, that is the duty of the being a deputy commissioner and the assistant director, deputy mines and geology has to written letter to the assistant commissioner and my lord forest department, and they have to submit a report to the my lord deputy director mines and geology department. Thereafter, it has to be considered. Deputy commissioner has written letter to the forest department. That is my lord in page number 34. Let them consider and pass order in accordance with law. That's all, my lord, my respectful submission. I am not seeking positive direction. Let them consider and pass orders.
My lord, in paragraph 7 of the writ petition, they know why, my lord, the DCF is not issuing the
That
NOC.
there is a earlier direction that my party has not filed contempt since there is no pass
He
order.
has to at least refuse otherwise.
Yes.
He has to do it. He has to either proceed or
Let them
refuse.
consider and pass orders in accordance with law.
Would have been a demand to consider.
Demand, there is a direction of this court.
This is the.
Application is pending, I understand. Very well, I'll look into it, my lord. May I have it 2 weeks and I'll place what is there before my lord.
See, it should be investor friendly. They are required to make only one,
I leave it to my lord.
Let them consider and pass orders in accordance with.
This petition filed under Article 226 of the Constitution. Direction is asked for against the respondent authority to consider the application dated 17/11/2004 of the petitioner for grant of release in respect of the
Survey number 123. Measuring.
123 at measuring 10 acres situated at where
Baila village.
where is the description?
Schedule in page number 12, my lord, schedule is there.
Page number 12. At measuring 10 acres situated at Baila village, Madhugiri Taluka, Tumkur district. Learned advocate Mrs. So-and-so would point out that after making application, the petitioner has paid amount of those 5 lakhs. It is further submitted that the respondent herein has received all the no objection certificates from the revenue department and other departments. However, the forest department has not submitted a report. Therefore, it is stated that thereafter the application of petitioner came to be rejected on 29/8/17. Full stop. The petitioner thereafter had an occasion to file a petition which culminated into order dated 21/9/17, whereby the endorsement of the rejection dated 29/8/17 was set aside. Despite the correspondence thereafter, nothing is yielded, therefore the present petition filed. It is fair enough. As such, it is entirely for the respondent authorities to consider the merits of the application petition for grant of lease. Full stop. It appears that the forest department has not so far decided on the grant of no objection to the petitioner or to refuse the permission. Post of figures on record. Letter dated 1/10/2022, addressed by the Office of the Deputy Commissioner, Tumkur District 2, to Deputy Conservator of Forest, Tumkur, regarding submission of report in connection with the issue of co-release license for pouring ornamental stone, by the petitioner as per the request of the petitioner, as per the application of petitioner. Full stop. The contents of the said letter. Would reflect that the authorities are in the process of examining the pros and cons of the request of the petitioner. Full stop. In that view, this petition is not liable to be entertained. However, since the application of petitioner is pending and petitioner is requested for grant of no objection certificate from the Forest Department, it would be incumbent on part of the competent authority to consider the application of petitioner and decide the same. Therefore, with limited observations that the competent authority respondent shall consider the aspect and take an appropriate decision strictly in accordance with law and on merits preferably within 8 weeks.
Lord, could I make one submission? My lord, if already not considered, my lord.
Full stop. The above direction will operate provided the it is clarified that this court has not gone into the merits of the case petitioner nor has expressed any opinion on merits. Paragraph. The petition is disposed of accordingly. Paragraph. The above direction and will operate. Above direction will operate provided the competent authority has not considered the application so far.
Yes, I'm obliged, my lord.
Obliged. Great.
Issue number 33, Sir Ranganath S. Joyce. Number 33.
Nobody is there, due date. First, we complete the board. Nobody is there. We go to toast. Delay is there. Stand over to 1st April.
Number 43. B.V. Nitishri.
For the petitioner, Your Lordship.
Appeal for respondent number 2, my lords.
So respondent number 2 has filed IA 1 of 25, seeking correction of the judgment passed by this honorable court. I'm praying time for filing the objections.
My lords, we have made an application seeking for correction, my lords, in this matter.
What correction? What is the correction you are seeking?
My lords, this matter, my lords, what was understood all through, my lords, was the basic pay that was payable to Class D employees was to be paid to the daily wages, my lords. But in the order,
Yes, you are that this is that minimum pay scale to the court.
yes, my lords.
So,
Para
what is
5 of the order,
What is the
it is reflected as salary, my lords. It would not be salary, my lords.
at par with the
Kindly see the order dated 27 January 2016, my lords, of this honorable court.
so the 5th line from below
Yes,
Daily
yes,
wages.
my lord, these daily wages have been.
already paid the salary. So salary is paid, salary is paid or not paid?
My lords,
Minimum basic. Full stop. Yes. Where is that being spoken? This arrangement I am not comfortable. This. Who is for the other side?
Well, I appeal.
So we correct it. Also, the present writ petition, which was disposed of by judgment and order dated 8/1/25, comes up for consideration upon the note for being spoken filed by respondent 2, in which certain factual errors are pointed out in the order paragraph. The errors pointed out are raised under. So, yeah, for full stop. The in the aforesaid paragraphs, comma. Full stop. Errors of transcription, which are in the nature of errors of transcription, which are in the nature of clerical errors, are pointed out, which are raised in the paragraph. It is not in dispute between the parties that the errors pointed out are the factual errors required to be corrected. In that view, the necessary correction as prayed for shall be carried out in the order. The order shall be issued afresh and accordingly uploaded in place of the earlier order.
Obliged.
The note for being spoken to is disposed of.
Grateful members.
Forty-four is adjourned. Number 45, Mr. D. Nagaraj. 45.
35. 45. Nobody is there. None is present. Stand out. 8th April.
Seal number 46. Mr.
This compliance
Here,
affidavit is filed, my lords, on 29th August 2024. And Sagoli chit has been issued as per the directions issued by this honorable court, my lords.
Mr. Kumar Swami.
The compliance affidavit dated is 29th August 2024, my lords.
With reference to what is stated in the compliance affidavit, our learned additional government advocate Mr. Raghavendra stated before the court when the present petition came up for consideration, that the direction of learned single judge to consider the representation of petitioner has been acted upon and that necessary endorsement is passed. Where is it?
Sagoli chit has been issued, my lords.
22/12/23.
Sagoli chit has been issued, my lords.
Where is that? Where you stated?
On 20th August 2024. Your lordship would get it at page number 14, translation copy, my lords.
And the necessary endorsement passed and the certificate regarding grant of Saguwali chit
Please.
is issued. Full stop. The necessary documents in substantiation are produced along with the compliance affidavit. Very learned advocate, the petitioner is not present in order to give opportunity to the petitioner's learned advocate to remain present, to be listed as last chance at 2:30 on tomorrow. Two more.
Please. Number 47. Mr. Sampath.
Tomorrow as the order is complied.
For the accused,
Or
my
for the
lords.
purpose of disposal, as the order is prima facie complied with and nothing survives in the petition, stand over to 6th of. Yes.
Number 47.
The complainant, my lord. Appearing for the complainant, my lord, the matter has been partly complied with, and the remaining is yet to be complied with, my lord. I
What is
seek a
not com-
short accommodation, my lord, senior, like to
What is-
address that.
What is not complied with?
Because there was a
What is not
complaint
complied?
about deviances in the, one person, Mahesh's property, my lords. And based on the directions of the single judge, we have issued them to pass the provisional order, final order, as well as we have issued a memorandum to clear the illegal structures concerned with the memorandum is at annexure R7 in page number 22 of the compliance affidavit.
What is not complied with?
My lord, senior will address the arguments, my lord. He will take up.
Senior.
Please.
My lords, one submission, my lords. As on date, the commissioner is transferred and he has passed all the necessary orders, my lords. In fact, the memorandum issued at page number 22, my lords, demarcating the authorities to oversee the demolition process.
What was the directions that is?
My lords, the direction was to,
That's all.
My lord, a short accommodation, my lord, anytime.
Why?
My lord,
Why you go to the direction?
my
Or
lord,
on the next occasion, we will argue, then we will grant. No
please, my lord.
senior.
Please,
All right. When do you want?
anytime.
At
Anytime
10th,
next week, ma'am.
on 10th at 2:30.
Okay,
But if a senior comes, we will not permit.
please, ma'am.
Yes.
Number 48. To submit this.
For the complainants, man. And
Lords,
opening the podium to rest work.
Lords, in this matter, the directions are twofold, my lords. The directions are twofold, paragraph 4 and paragraph 5. So far as paragraph 4 is concerned, to ascertain whether the land falls within 18 kilometers, my lords. That has been done, my lords. Thereafter, the court proceeds to pass an order to conduct Podi and Durasti. In respect of that, we have preferred an appeal, my lords, because it falls within 18 kilometers. Writ appeal number 157 of 2025.
When it is coming up?
That's
We listed with writ appeal number
157 of 2025.
157 2025.
I haven't received any copies, it may be direct. I
I'll
haven't received any
serve them.
copies with respect to the writ appeal.
I'll
They may be
serve
directed.
it.
They will-
Obliged.
Since the order under contempt is impugned in the side of, is challenged in the side of.
Number
Thank
49. The HR Ananta Krishnamurthy.
In this case, my lords, I'm filing the compliance affidavit on.
You copy.
Please. I'm sure the copy along with all the documents, my lords. In 2 sets to.
A bit mistake, today only I received a copy. The proper survey is conducted on that extra time with the party. But all the parties have not signed the.
Police protection is given.
My lords,
They are
But-
seeking some police protection.
police protection is given, my lords, when there was, it was misled in the writ petition, my lords, stating that to conduct this sketch in pertaining to survey number 195/3. But there is no existence of survey number 195/3. Instead, it was overall as one.
That has been cancelled, my annexure H1, my lord. Annexure H1, that's page number 58, this one translation was, my lord. That was actually cancelled. Now directed to conduct a fresh survey. 58, your lordship, turn to the.
All right, consider the reply.
Please.
3rd April.
Yes. For non-compliance of the order, page number 50. Well, in earlier round of litigation, my lord, my colleague has, my lord, he has agreed to comply with the order passed by the, my lord, learned single judge of this honorable court. But, so as to restore the entire revenue records pertaining to the property of the complainant hearing. But page number 15.
Page number
15, my lord.
50.
Bla-
50.
Please, Annexure A, page number 15 is the order, my lord. The earlier contempt petition was filed, and in that contempt petition, the specific direction was given to the, my lord, accused to comply with the order within 6 weeks. For the relevant page is at page number 17. In 2017, when writ petition has been filed, that was allowed. Thereafter, my lord, that was also not complied. In 2020, when writ petition has been filed, that was allowed. That order was also not complied.
On 30th September 2024, my lords, Assistant Commissioner has passed an order, my lords. I would like to bring it to notice of this honorable court, my lords. So,
There are 2 writ petitions order, my lord, and 1 contempt petition order, my lord, in favor of the complainant hearing. Still, they are not, my lord, comply with the order passed by this honorable court.
on 30th September 2024, my lords, the Assistant Commissioner has passed the order, my lords, complying the order. My lords.
You
And please,
first you give to your learned, then give to us.
Lord, week's time may be given. I will verify, my lord, I will
No,
come back.
no, let us see what is it.
order is passed pursuant to the order passed, my lords, by this court dated 4th July 2023, my
this?
lords.
Some order you are.
Please, my lords, on 4th July 2023, my lords, your lordship has passed an order, my lords. The relevant part is at page number 22, my lords. The respondent 1 and 2 are directed to restore the revenue interests which are prevalent prior to passing of the order in so and so, and the corriginum dated so and so to the writ petition in respect of the land subject to the matters said. The same shall be subject to the final outcome of the decision taken by the respondent number 1. That was the case pending before the Assistant Commissioner, my lords. In terms of the same, my lords, now on 30th September 2024, my lords, the Assistant Commissioner has passed an order, my lords. Subsequent to the order passed by this honorable court, my lords, that is on 4th July 2023, my lords, page number 22, my lords. The case pending before the Assistant Commissioner was pending, my lords.
Produce whatever you want to do by name.
Please, ma'am.
To be prepared, Mr. Counsel. Not satisfied with your submissions in any matter. Yes.
So, if my lord, week's time given, my lord, I'll verify, my lord, I'll get back.
28th of April.
Mr. Vasant Kumar, HT, 51.
Before they respond, the process of compliance is under process, Lord may grant us 3 weeks time,
7th April.
please.
7th April, yes.
52 disposed, 53, Mr. Vinayak B. Vishnu Bhatt.
Nobody is there, 8th April. None is present, stand out to 8th.
Number 54. Vaishali Hegde.
Yes.
For the complainant, my lord. Yes, my lords, the learned single judge had directed reinstatement of the complainant along with all consequential benefits. He has been reinstated, my lord, but consequential benefits have not been paid.
Who will appear? Yes, Mr.
Please, my lord, there has been reinstatement made, my lord, and today even charges has been given today, my lord. Posting is also been given, my lords. Now, my lords, there is a condition, my lord, that the Lokak has preferred a writ appeal, my lords. Subject to that, the consequential benefits still not yet been given, my lords. Pertaining to reinstatement and posting has already been given, my lords, and he has resumed, he has, on today, my lords, posting has been given, my lords.
My lord, consequential benefits also was a part of the learned single judge's order.
They are saying that writ appeal is preferred.
My lords, in that case, this contempt may be connected with that writ appeal, my lords, and may be made subject to the outcome of the writ appeal.
The order which is brought under the contempt petition has directions in two parts. First is that the petition will be reinstated immediately. The second is that the petition will be entitled to all consequential benefits arising out of this reinstatement, including the arrears of salary. When the petition came up for consideration today, learned additional government advocate Mr. Raghavendra produced copy of order. What is this order? Office order. Office order dated 5/3.
Reinstatement, my lords. Reinstatement of the complainant, my lords.
This is office order.
Please, my lords. And also today he has given posting, my lords.
This is office order or what? How do you describe it? Office order dated 5/3/25.
The official memorandum, my lords.
Which shows that the petitioner is reinstated and the posting is also given today. Full stop. The other part of the direction regarding payment of the consequential benefits arising out of the reinstatement is yet to be complied with. When you will do it?
Short accommodation, my lords.
When you will do?
2 weeks, my lords.
Learned additional government advocate made a statement in this regard that the consequential benefits shall be paid to the petitioner within 2 weeks. It is provided that the consequential benefits arising from the reinstatement already done shall be paid to the petitioner within 6 weeks from today.
Please, my
Full
lord.
stop. With above observation, the contempt petition is disposed of. With an further observation that if the rest of the part of payment of consequential benefits are not complied with within the aforesaid stipulated time, the respondent shall be exposed to aggravated form of contempt.
Grateful, my lord.
Seal number 55, Mr. Vivek Volda.
For the petitioner's counsel, 99, my lord, we applied for regularization of unauthorized occupation. Committee for, there is a committee, my lord, for regularization unauthorized occupation order. Notwithstanding that, my lord, after 20 years, my lord, we are still struggling. All the order was passed by your lordship's court, my lord, to consider and pass appropriate orders, my lord, within May, page 174. This honorable court earlier, my lord, held that, my lord, yes, I am entitled, my lord, all that. Then they said, all right, liberty is granted to you. Page, my lord, 62. 61 bottom, 62, and then, my lord, liberty, they sought liberty, and then, my lord, that liberty was given.
Page 174, my lords, was direction to conclude the entire proceedings, my lords. The proceedings has been concluded and order is passed on 23rd January 2025, my lord. In LND audit 2 of 2021-22, my lord.
That's all right, you'll have to challenge this.
Page 174, my lords.
In fact, Distance.
So it is concluded.
Lord, I don't want to say anything, but please have a look at page 81 for a minute. Order of the learned single judge. The order, my lord, the actual order, my lord, I mean, the learned single judge's order, my lord, starts at 34 at 81, para 3.
That is not part of the order.
My lord, no, I agree, my lord. I entirely agree with your lordship. But what I am saying is, the order is distance certificate be seen. Distance certificate was accepted by this honorable court, and then, my lord, my writ petitions allowed. Anyway, I am in your lordship's hands, my lord, whatever your lordship.
81.
Yes, my lord.
Table
58, my lord, sorry.
88.
58.
50.
Sorry, my apologies.
Yes.
Having para 3, my lord, having heard the learned counsel of the parties, having perused the petition paper, this court is inclined to grant indulgence in the matter as under for the following reason. Petitions that applied for regularization of the unauthorized occupation of the subject lands. Accordingly, Committee for Regularization of Unauthorized Cultivation has passed the subject resolution recommending their case is not much in dispute. Statutory committee inter-alia comprised of Tahsildar or the Taluka concerned as a member. He happens to be its secretary ex officio in terms of so and so. Section 94A of the Karnataka Land Revenue Act cannot be disputed. Same being a part of the statutory scheme, Tahsildar did not register his design.
94 is the distance.
94A is, my lord, the distance certificate. And they have said that, my lord, yes, it is within the limit. Now, my lord, after, my lord, 22 years, borders have increased. Your lordships have held, my lord, in other cases that yes, my lord, on the last occasion, my lord, 2 days back, my lord, similar matter came up before your lordships. This is how, my lord, we have been struggling for the last.
Challenge.
Please.
Sir, 56, Shiv Prasad Nayak.
For complaint, it's a case for unauthorized regularization of the cultivation of land. Single judge, honorable court, single judge passed on the order dated 13/7/2023, my lordship. This is a more than 20 writ petitions are common order passed. In this common order, my lordship, in the page number 42, my lordship.
That's the committee has been constituted and the application is placed before the committee. And on the commit, the hearing date is fixed on 18/3/2025 minutes.
My lordship, annexure B, I have given a request letter to the Tahsildar.
Principal secretary to directed to take steps to have the committees constituted. Committees to be so formed the director consider applicant.
Committee is constituted application.
My lordship, I have filed the request letter before the Tahsildar and the Tahsildar secretary. But they have not informed anything. We have committed the, formed the committee. This is the annexure B 43 and 44, my lordship. A typed copy in 45.
In order dated 14/7/23 of learned single judge while disposing of the writ petition, following directions were received, which are now made contempt, which are now made subject matter of contempt jurisdiction, alleging breach thereof. These are the compliance affidavit, which was relied on by learned advocate for the learned additional government advocate. This from the negation. It is stated inter-alia that committee for regularization of the unauthorized occupations and cultivation has been constituted in the Devanahalli Taluka by notification dated 5/3/24. In that view, contempt will not survive. Hence, the directions are complied with. Petition is according to this post.
Fifty-seven is urgent. Seal number 58. Adavishaya B.
Represent the complaint, my lords.
None present for the petition. Yes, you are present or not present?
I represent.
Present.
The accused has committed an contempt, my lords. The order passed in RA.
IA. Where is that order? Page 21.
Yes, my lords. Page 21, my lords. The respondents.
This is in appeal before this court. Could be. Yes.
My lords, the accused has committed an contempt, my lords. He has not executed the sale deed as ordered in the OS 118/24, my lords. Sorry, my lords. So, RA 69/2016, my lords. He has sold the suit property to the third parties, my lords. Annexure G, my lords. The sale deed.
You are appearing for the first time before the High Court?
Yes, my lords.
First time?
Physically appearing, my lords. This time is video conference.
So why don't you appear with better matter? Here you file execution, Mr.
I have already filed execution, my lords. He has already sold, my lords. Annexure G, my lords, page number 93, my lords. The suit schedule properties have been sold, my lords.
Of this court under the Contempt of Courts Act 1971 is invoked by the petitioner represented by learned so and so, comma, in respect of order dated 16th April. Judgment and order dated 16th April 28 passed by the Court of Learned Additional Senior Civil Judge Gugge in regular appeal number 16 and 16. Full stop. The operative part of the order reads as under page 20 and 21. Full stop. The aforesaid order for its compliance has to be executed by filing execution petition. Full stop. Remedy of execution petition before the competent court is available to the petitioner. Since the remedy as above is available, the contempt jurisdiction not excisable. The contempt petition is dismissed, reserving liberty for the petitioner to file execution petition as may be permissible in accordance with law.
Much obliged, my lords.
The appeal will pass.
Number 59, Anjar Reddy PN.
Yes.
59.
For the accused, my lord, I have already filed the memo for compliance, my lord, before the court. We have already complied the order, my lord.
Who is for the petitioner?
PN Anjar Reddy.
He's already complied, my lord, and also they have received the amount.
Nanja Reddy PN. Where is he? Learn, will keep complied with?
Complied, my lord. Kindly,
What is the
I have filed the memo. My lord, the compliance order is at page number 28, my lord, the relevant page. 38, my lord. Last portion, ma'am. Further, if the petitioner is entitled to difference of retirement benefit in the cadre of general manager, even the same to be calculated, such calculation shall be made and amount shall be distributed within a period of 8 weeks, along with, we filed an appeal, my lord, appeal got dismissed, my lord, then we went to SLP, that is also.
Notice paid
Now amount is paid, my lord, I have filed the compliance report, my lord,
with interest.
with interest, my lord, 6% interest. That DD also have, check also have enclosed, my lord, and also it has been credited to his account, that also I have produced before. At page number 4. ma'am.
Following are the directions in the order of learned single judge dated 3rd June 2009 while disposing of the petition which are made subject matter of contempt. So paragraph 945. When the petition comes up for consideration in absence of learned advocate of the petitioner, whom it was stated by learned advocate Mr. So-and-so, the respondent that directions are complied with. He invited attention of the court to the compliance affidavit dated 28/10/24, which figures on record evidencing the not compliance memo 28/10/24, in which along with which the communication dated 14/10/24, copy of the check and the bank statement are produced to show that the amount of rupees 13,95,450 towards the payable dues to the petitioner is already paid and
Please.
credited in the account of the
It has been
petitioner
debited from our
after-
account. ma'am.
since the counsel, the petition is not present to be listed at 2:30 on 10th of
Please.
March.
System number 60, Mr. AJ Srinivasan.
My lord, this is for the gratuity towards the professors, my lord. And we had gone to the single learned single judge because there was order by the controlling authority and which was not complied with, and the gratuity was not deposited, no appeal was filed. And the recovery certificate, the DC had not recovered the amount. So we, in accordance with the Payment of Gratuity Act, we sought a mandamus, and the court only said that the DC should recover it and pay it, my lord. And this, my lord, they have not complied with, that is both the management, that is the institution was directed to deposit that amount. That has not been complied by the institution. And then the DC as such has initiated recovery proceedings, my lord, but section 8 of the act says that it should be recovered and paid to me. That has not been done, my lord. And though they claim that they have filed an appeal, my lord, that appeal is also been dismissed for default. And my lord, whatever challenge this institution has done is in respect of the amendment to the act, my lord, that also the division bench of this court, relying upon the Supreme Court judgment, has said that teachers are also entitled to gratuity. That amendment is a valid amendment, is what the Supreme Court has laid out. Absolutely, there is no reason why they should not pay the gratuity and this.
Labor officer and controlling authority on 23/9/2024, and to that effect, an endorsement is also been issued, my lords, and compliance affidavit is also filed, my lords.
That is not full compliance, my lord. Section 8,
Lordship,
my
may
lord.
kindly see.
Section 8 says that it should be recovered and paid to the workman who is entitled to it. Only then full compliance of the learned single judge is said, in accordance with law, you should recover and pay it.
it will be completed only after it is paid, that what is recovered has to be paid. I came before the court. The workers, my lord, they had to approach the court only because
It is complied with.
Please, my lord.
It appears to be complied with.
your lordship may kindly see section 8, ma'am. Section 8 of the Payment of Gratuity Act says it has to be recovered and the amount along with compound interest is to be paid to the worker. That last portion of being paid to the worker has not been complied with. It is not enough if you just initiate the recovery proceedings and it is deposited before the authority.
Last portion, my lords, liberty was given for the deputy commissioner to initiate recovery, my lords. It was a liberty, my lords. So far as the amount is concerned, it has been deposited, my lords, before the labor officer and controlling authority.
Section 8 of the Act says, my lord, the interest is to be collected after the expiry of prescribed time as arrears of land revenue and pay the same to the persons entitled thereto and being paid to the persons entitled thereto. Only then their duty, mandatory statutory duty is completed. That has not been done, my lord, as required under section 8. And as far as the institution is concerned, my lord, they are also at default because they ought to have paid. I made them also a party to this in the contempt.
See, in fact, they are at default. You can't
Default.
call up the deputy commissioner over here.
My lord, the direction was to both. In case they don't do it,
See, district commissioner is at liberty to initiate recovery proceedings in accordance with law. No specific direction is issued to him.
in accordance,
Direction is issued to respondent number 2 and 3 institution to
Yes,
pay the gratuity
my
amount.
lord, either way, my lord, they are. I made them as a party. The institution is a party to this. My lord, page 13, my lord, 13 of the contempt petition, my lord, is the order passed by the court, my lord. There, the institution is directed as ordered by to the petitioners. The direction. The direction
2 and
is,
3 are served.
my lord.
Accused 2 and 3 are served.
Yes, my lord. That is what the the notice says, my lord. It is served. So 2 and 3, they represent the institution. They have to pay it. Unfortunately, they are very, very powerful people who are in the government now, my lord, in power. Oh, ಇದಿಲ್ವಾ?
What 2 and 3 have done? Government. Accused number 2 and 3. See, the direction is issued against the private party, 2 and 3, right?
That is not my 2 and 3 have deposited the amount before the controlling authority, my lords.
They have deposited the amount. Is
They
it?
have deposited, that is my complaints affidavit states, my lords. For an amount of rupees 10,97,370 and 6,07,562 is what they have deposited before the labor officer and controlling authority, my lords.
Thereafter, who has to release it in their favor? How it has to be released?
My lords, they has to make an application before the controlling authority to release the amount, my lords. The amount what they were entered for gratuity has been deposited before the labor and controlling authority, my lords.
But the direction says that the petitioners have to be paid. The petitioners have to be paid as directed by the controlling authority. Page number 13.
Please, my
Yes,
lords.
my lord, 13. within a period of 4 weeks from the date of release of this order, failing which the respondent
Period of-
one.
It says to the petitioner within the period of 4 weeks, my lords, but the institution is deposited before the controlling authority, my lords.
Who is the controlling authority?
Labor officer, my lords.
Controlling authority, my lord, they were not directed to deposit there. They on their own, they are not complied with this order.
Can't you go ask him to pay you the money? Will he not pay or will he object to it?
They will not, my lord. That is why I am before this court, my lord. Because they have not done all that, I had to rush to this court for a remedy, my lord. The court has also passed an order to granting that remedy. That has not been complied. That is the problem, my lord. That is why this contempt I have filed, my lord, instead of. All these institutions are very powerful people, my lord. They are quite.
No, gratuity is to be paid to the person concerned, no.
But the 2 and 3 are deposited before the controlling authority, my lord, instead of paying to the petitioner, my lords. Your lordship may kindly say, my lords, this contempt petition is filed on 3/9, my lords.
Now, what does the law contemplate?
To the
Section
petitioner,
8, my lord, Gratuity Act, your lordship,
But
is
the-
section 8.
But the institution is deposited before the controlling authority, instead of paying,
Full compliance of section 8 says, my lord.
they have to answer, my lords. Respond number 2 and 3, my lords. Lordship may issue notice to them, my lords. They have to answer, my lords, why it has been deposited before the labor officer instead of paying to the petitioners.
It says it has to be recovered and paid to the claimant. The claimant is the workman. And pay the same to the person entitled thereto. Pay it to the person entitled thereto is section 8. Recover it. So, if they were to initiate recovery proceedings in accordance with law as directed by the court, it will culminate in the payment. It will not end with just recovering.
Bailable warrant.
My lords,
We're issuing bailable warrant.
lords, the notice, to respond number 2 and 3, the institution, my lords, notice has to go to them, my lords. Instead of giving it to the petitioners, they have deposited before the labor officer, my lords. They have to answer, my lords, why such act has been done, my lords. Your lordship may issue notice to respond number 2 and 3, my lords.
2 and 3. Who are
They are served, my lord. Non-filing is what is reflected in the cost title, this one. Non-filing of reply by A2 and A3 in spite of service.
notice returnable to this one, 1 and 2. 2 and 2 and 3. They're served.
And one other aspect, my lord, section 8 says compound interest is to be levied. They have not recovered the compound
Security
interest.
amount is not paid at all.
not recovered compound interest. They have just deposited the principal plus some simple interest, it appears. Compound interest is what section 8 says. If you have to recover
the
it.
Amount without compound interest is deposited.
Deposited is
Yes.
what they have said in their complaints affidavit.
So that can be.
They
moved
have to
withdraw.
recover compound interest is what the mandate of the act.
You want to withdraw that?
No.
You want withdrawal of that amount? This contempt now.
My lords, 2 and 3 has to answer for this, my lord. Institution, my lords. We were only the liberty to initiate recovery proceedings, my lords, in other cases.
Initiate recovery proceedings will only be recovery of compound interest and payment. Then only their duty, they would have statutory duty, they'll perform.
So you can apply to the, where it is deposited?
Before the controlling authority labor officer, my lords.
You apply, will permit you to withdraw.
With compound interest, your lordship may say, my lord,
No,
in
whatever-
accordance with section 8 of.
Whatever amount is deposited, you first withdraw, then any calculation error is there, we'll see what to do.
Very.
Please.
It was stated by learned additional government advocate, Mr. Raghavendra, that amount of gratuity ordered by the controlling authority has already been deposited,
Please, already
the controlling authority.
by way of demand draft, my lord.
Hmm?
Deposited by way of demand draft, my
By
lord.
way of demand draft. Full stop.
As per Annexure R3.
Petitioner is liberty to approach the controlling authority and withdraw the said amount, which will be in compliance of the directions of law and a single judge as contained in paragraph 8 of the order. The deposit of the amount as above marks substantive compliance of the order of law and a single judge by the respondent authorities. Petition is accordingly disposed.
Lord, I think it should be kept because if it's not the amount
You have said that
with
it is
simple
the
interest,
petitioner.
it will not be
It will be open
compliance
for
of
the
the.
petitioner to approach the controlling authority with an application for withdrawal of the amount. If such application is made, the controlling authority shall permit the withdrawal after undergoing the necessary procedure of identification, etc. Any
Compound
the-
interest.
The petition is disposed of, any calculation dispute, if arises, may be resolved intercept by approaching the competent authority.
My lord, liberty to file a contempt in case.
Liberty to file appropriate proceeding is reserved in case of genuine difficulty.
Much. Okay.
Number 61,
Accused in this matter, my lord.
disseminate.
This is second round of litigation and contempt proceedings, my lords. On earlier occasion, my lords, page number 25 may kindly be seen, my lord. Learned advocate for BBMP, my lords, has assured this honorable court, my lords, that it would, the order of this court, my lords, would be complied within 2 weeks, my lords. Almost a year has passed, my lord.
But this representation is not
Part
decided.
payment was released yesterday, my lord.
I request, my lord, I'm filing the compliance affidavit, whereas the single judge, my lord, has told us, has ordered us to pay the salaries. Salary is already paid, my lord. Entire salary has been paid.
No, my lord.
Page,
Pensionary and pensionary.
Kindly see- kindly see page
Already
10.
retired from government, retired from service, my lord.
kindly see page 12, my lord.
Page 12.
12 of the contempt petition. I read that the grievance of the petitioner as per representation dated so and so is that the respondent BBMP has not paid salary due to the petitioner from so and so. Therefore, I am of the view that the respondent BBMP shall consider the representation dated so made by the petitioner within the outer limit of 8 weeks from the date of receipt of the certified copy of the order. Salaries are paid, my lord.
Kindly see page number 21, my lord. Last paragraph, the honorable court was last paragraph.
Page
from
number?
Page number 21, my lord.
21.
21, my lord.
Hmm.
The honorable High Court was pleased to allow the aforesaid writ petition on 14/3/2023 with a direction to consider my request in the representation dated 31/1/2018 vide annexure A5 for the release of monetary benefits to me. Xerox copy of the order dated so and so is also enclosed for reference. The items, my lords, are page number 22, my lords. Arrears of salary, arrears of salary retirement pension, and etc., my lords. They released only arrears of salary, my lords. He has already retired from service, my lords. He is now 67 years old, my lord. Pension and pensionary benefits have not been released till now, my lord.
No, the direction is for salaries, my lord. I'm not sure about the pensionary benefit, my lord.
The representation-
Direction at 12, my lord, at page 12 is only in regard of, yes.
10th at 2000.
10th March.
10.
Grateful.
Number 62. Shilpa Rani.
I received the complainant's affidavit by the complainant, respondent number 1, my lord. Neither he have produced the attendance of my complainants, my lord, neither he, nor order has been passed, my lord. He have not taken me back to service, my lord. This honorable court order has not been complied by the accused, my lord.
Which order was?
My lord, annexure A, my lord, page number 27, my lord. There is a specific direction by this honorable court, London single judge directed not to dispossess the petitioner who was still rendering the services, my lord, in the second respondent institution. That is
Notice.
accused number 1, my lord.
Notice is already issued.
Notice
Lords,
was
again
already
for-
served.
My lords, in fact, we filed compliance affidavit, my lords. The earlier order of transferring the complainants has been withdrawn, my lords. The same has been placed, if I may, my lords, due to inadvertence, my lords. The translated copy of the said documents were not filed, my lords. If I may be permitted, my lords.
This transfer order, my lord, 31/12/2024, this is December, my lord. My learned friend itself is produced attendance, my lord, in January, February, they are not produced, my lord. They are still working, my lord.
Today you are working.
I'm not working, my lord. They're not taken me back service, my lord. They're not even passed order to taking back service, my lord.
The date of order you are working.
On the date of order, I was working, my lord.
How do you say that?
My lord, on that 20, may take page number 33, my lord, annexure 3 transfer order, my lord. They have placed me, my lord, on 37/2024, July 30th. The respondent number 1 other who has transferred regularly, my lord, came to my place, my lord. And dated 30th July, my lord, until I was working, my lord. And also I have given any representation, my lord. Annexure D is my representation, my lord.
Please.
Annexure D, page number 43, which is in Kannada, my lord, translation copy, my lord. Page number 46.
Yes.
That time I was working, my lord. August, they have placed some other teachers to my place, my lord. Hence, I have given a representation. There is a stay order by this honorable court, and also there is a final order by this honorable court saying that not to disturb my place without filing any appeal for that writ petition order, my lord. That is reached finality. They not even challenge the order, my lord.
If they were in service on the date of the order, then how can you relieve?
My lords, in fact, my lords, my compliance update and the translated document, my lords, at page 8 of the memo that's been filed before this honorable court, my lords. In fact, the order specifically enumerates, my lords, there's withdrawal of services of the persons who were posted there, my lords. There's withdrawal of services of the persons who were posted there. Specifically, the institutions wherein these persons were posted, there was additional posting given, my lords, that has been withdrawn by way of page number 8, my lords, the translated version of the memo, my lords. There's an official memorandum, my lords, with regard to the withdrawal of the transfer order of staff transferred in general transfer in the background of the contempt of court case filed in the Honorable High Court, my lords, before the Honorable High Court. page 8 of the memo, my lords, that came to be filed.
My lords, my learned friend says, my lord, he's withdrawn December 31st itself. But why they're still working, my lord? There is no order to continue the complainants, my lord, in the same institution. There's no order passed by the accused, my lord.
My lords, they get to automatically take
And
charge, my lords. The order has been withdrawn, my lords. They automatically get to take charge. They can,
There is
the
the-
said place is vacant, my lords.
They not passed any order to take back services, my lord, to the complainant. Even the attendance they shows, my lord, in the January also, their name only is showing, my lord. February attendance they are not
In fact,
produced, my lord.
page 3 of the memo, my lords, clearly says, Kavita MJ, we withdraw this teacher's order, my lords, general transfer order, and relocated to Indira Gandhi Residential School, Chitradurga. She was relieved from duty on 1/1/2025, my lords, in the afternoon. It's been recorded in the attendance sheet also, my lords.
If it is so, my lord, they have to pass an order and I'm still jobless, my lord. They have to call for a job.
Now
We are
come to
ready
the order passed by the
Yes, my lords.
Senate single judge.
Page number 27, my lord.
Read the respondents are hereby directed not to. Read that.
Sir, the response are hereby directed not to relieve the petitioners if they are still rendering the service in response number 3 society against the vacancies subject to filling of these vacant posts through proper recruitment process, my lord.
Now, were they relieved or not as on
My
the
lord-
date of passing of this order?
My lords, they were continuing their services, my lords. This was just
They were
general
continuing-
transfers or regular posting that was
Now
made.
show it where you have posted them.
My lords, in fact, we have withdrawn the order of posting fresh candidates to the said post, my lords. So hence it becomes vacant. In view of the,
Fine, show a document to show that they are serving over there.
my lords, in fact, I'll try to ascertain and get the attendance copy, my lords.
That alone will not do. You
Well,
should
they're
be
marking
paying
their
them
attendance
salary
now.
also.
My lords, I'll
The
instruct them to.
better thing would be to show that you are paying
My
them
lords,
salary.
in fact, my instruction was that they're already continuing the service. I'll instruct them to send me the official document also.
If you pay them the salary, they will not be interested in attendance also. They will not be interested in anything else.
No, my lords, we'll ensure that all the documents are placed before this honorable court, my lords. In fact, we were under the assumption that attendance
Because
records.
it is a specific contention that in spite of the order, they are not taken back to service.
My lords, in fact, I'll try to get the latest attendance records, my lords.
And the payment made also, because see, this order was passed in when? December?
2020, yes,
26th
February,
February
26th
2024, my
24, my
lord.
lords, 24.
So now it's
1 year, my lords.
1 year.
1 year up.
Yes.
So 1 year salary you show, that takes care of everything.
My lords, I'll do the need. I'll take necessary instructions on that and file necessary
Along with
compliance.
other documents,
In
whatever
fact,
you want to
the
place.
instruction is that it's compliant, but I'll do the needful, my lords. As per.
When?
My lords, 1 week's time, my lords.
24th.
24.
Number 63, Amit Nayak.
I appear for the complainant. Lord, this petition is filed for non-compliance of order dated 1/12/2020 in WP number 13774/2020, my lords. My lords will find the order in page number 12, my lords. The specific order, if I may read, my lords, is in page number 15, para 5. It reads, my lords, may I read, my lords? In para 5 in page number 15, my lords. As regards prayer B, it is the duty of the state government to ensure that if liquor is being illegally sold on a complaint received in that behalf, immediate action is taken to preventing illegal sale of liquor. If an organization of women makes such a complaint, it is all more necessary for the state government and its office to act very expeditiously, considering the rights of women. Hence, the state government shall take action expeditiously. My lords, in this case, a notice was issued on the last date, my lords. Respondent number 4, who is the excise commissioner, they have filed some affidavit. I have received a copy of it, my lords, but that affidavit is incomplete, my lords. They have produced some tables to demonstrate what action was taken and what steps they have taken, what are the complaints they have received. That table itself is incomplete, my lords. I request if they provide the entire
We have
copy.
filed a detailed compliance affidavit, my lords. What are the measures that have been taken in respect of such complaints, my lords? The compliance affidavit from paragraph 4 onwards, from that date the order has been passed. What is the compliance that has been made, my lords, is enumerated here. Lords, on 23, paragraph 4, my lords, on 23/3/2021, Lords, the Excise Commissioner, by way of a letter, has addressed all the joint commissioners and deputy commissioners in the entire state to take note of the sale of illegal liquor and the complaint received exclusively by women organization and general public and take action in accordance with law. The direction has to be strictly implemented by all the joint commissioner and deputy commissioner. My lords, we have produced that letter. Pursuant to that, what has happened, my lords? Pursuant to the said communication, the data with respect to number of complaints that we have received from general public and action that has been taken, number of cases, that is FIRs registered, quantity of liquor that has been seized, number of vehicles that has been seized, accused persons
That is
arrested,
exactly missing
cases
in from my
registered.
affidavit, my lords.
Let me
They have
submit.
not provided a copy. That table itself is missing. That is why I sought for a
Lords,
proper.
they could have said that we give a copy.
That is what I had submitted, my lords. If they provide me a proper set, I'll be able to ascertain and reply to that same. They have in their affidavit, they talk about number of letters issued, my lords. But what action has been taken is not forthcoming.
See, the only direction is to act in accordance with law, which they have said,
Please.
how they are acting, that's all.
We have issued
In fact, there are,
circular
my
also.
lords, there are complaints that are being filed even now, my lords, on which there is no action being taken. In their
Cannot be
affidavit,
monitored in this case, counsel. That cannot be monitored over here.
please.
What is the direction issued?
What action they, if to take action, my lords, if they have demonstrated what action they have taken.
They have stated on an affidavit and that's the end of it.
Please, I just want to ascertain that based on the table they have provided, if they provide a copy of it, because the copy in which they have provided, my
But
lords,
you will not be able to ascertain. Once they submit a report, you will have to simply accept it. Access to that information at all.
I pray for just some time to look into this affidavit and I'll come back, my lords. May I just
And I don't
ascertain?
think there is any illegal liquor being manufactured in Karnataka.
No, my lords, all the
It's
data
only
is.
maybe sale of liquor.
That is the complaint, my lords. Sorry.
Let's kindly look at the affidavit and we have demonstrated what is the action that we have taken, how we are monitoring it and how effectively it is conducted,
even-
my lords, is.
Even in my contempt petition, my lords, I have filed complaints that are filed
Many
from
people
2020
are
to
arrested.
23.
How many people are
May I just
punished?
have a look at
All
the
data
affidavit
is
and I'll come back.
provided.
Dismissed.
My lords, I pray for 1 day's time. Let me have a look at it.
Otherwise, we would have granted.
Hello. I just pray for 1 day's time to have a look at it and I'll come back. Please, my lords. May I have it tomorrow itself, my lords?
Day after. Like 2:30.
Number 64. Radhinaranappa.
I have completed the court direction. I produced the. Deposited the cost and produced the acknowledgement.
Really, submit.
So what is contempt? Appeal.
No, writ appeal.
Long in this.
I have one for dispensation of annexure C in the
Petition is allowed, lease dated, executed by the second respondent in favor of the third respondent is post. Petition is permitted to operate the facility.
Well, I
I am for R1. I was permitted to operate this pay and use toilet because I have invested some money on that.
Till the tenders are finalized.
There was no tender. Admittedly, there is no
There
tender. There was an
I am
agreement.
the action purchaser, I am the highest bidder in the tender.
Thing
I
is-
was allotted the,
No, the thing is, please, my lord. 2021,
the,
2021, they
before the
executed an
single-
agreement. That is why,
Single
please, my
bench.
lords, I have invested money. Only time-bound order is passed, December 31st, 2025, I was permitted to operate because I have invested and renovated the pay and use toilet. Of course, there was no tender. They have entered into an agreement. During this period of agreement, they call for tender and execute.
Who is for city municipality?
I am appealing for the.
When you are going to issue tender?
My lord,
Tender when you are going to issue?
tender, during the force of the agreement, tender was called, my lord.
How?
Now we are operating, my lord. My municipality is operating, my lord, now.
Municipality is operating.
Municipality is operating, my lord.
Municipal corporation, may kindly see the order at
Kindly
page
see
18.
Page 19, page 19.
Petitioner is not operating.
No, my lord. Appellant or respondent is not operating. We are operating, my lord.
My lord,
They are operating, they have to permit me, please, my lord, till completion of this period at least, because I have invested. Lordship, may kindly see page 19.
may
page
kindly
19.
see the order at page 18, para 2. It should emerge from that petitioner is continuing to operate the aforesaid facility, but the learned counsel for the petitioner submits that this facility is now maintained by the second respondent itself. That is, I am the second respondent. I have to maintain as per their own submission.
In the writ petition, we are the respondent number 2, my lord.
Single,
Para 4, page 18.
My lord, in the writ petition, $25 $2025
They call for question, in which the limits in the clause they will have permitted the end of the zone.
That municipality asked me to invest this thing without calling for tender. I have invested around 4 to 5 lakhs. Only
Sir,
to-
1 second. Now it's a pay and use toilet,
Yes,
pay and use toilet.
yes, please.
Municipality asked you to renovate it.
Renovate it at my cost.
Okay,
Spending my money.
whatever it is, you have renovated it. There are two ways of looking at it.
Yes,
Because you are a social service organization, a non-profit organization. Number one, you have renovated in pursuance of your objectives without expecting any returns. Then in that event,
my
then in
lord,
that event, you would not be entitled to any lease of the property. Number one.
please.
Number two, even if they have asked you to renovate it and you have spent on it, you are entitled to recovery of the money that you have spent on it along with interest as the case may be. The municipality in law cannot grant you any lease to run or license to run that premises. They have to either run it themselves or float a tender and choose somebody else. Choose somebody else. And the question of your contention is they had promised to give you for a period of 12 years.
Now I am not contending for that.
Ah.
That learned single judge has permitted me to operate it only till 31st December. Lordship, may kindly see. Para
We
4.
saw it till 31st December 2025.
That's all. Limited period, it's a final order.
But the
At least-
point
at
is
least to that extent, 4 or 5 lakhs I have spent, renovated it. It was. in a very
that you
bad-
can sue them.
My lords, going to a civil suit, and that point came before the learned single judge. That point also arose before the learned single judge. Then I told that instead of this thing, permit me to do this. Lordship, may kindly see the order. However, page 18, one minute I'll take. However, in the particularities where the petitioner is permitted to invest.
We'll do one thing, we'll record the malfeasance and misfeasance on part of the municipality and we'll reserve the right for you as well as the appellant to sue the municipality and recover whatever money they want, that's it.
My only submission is, after this period, they were asked to call for a tender. After this period.
Disposed. Disposed.
My lord, I have not filed the wakalat, my lord. My name will be Chu.
You say last 11 advocate means so and so, you permit to file wakalat now, within 1 week.
Obligement.
If wakalat now is filed within 1 week, it shall be accepted by the.
Yes, my lord, please. Obligement.
Number 65. The Purnima. Number 65, so Purnima S, 8 office objections with mint evidence.
Nobody is there. Office objections shall be complied with within 3 weeks. Failing which the appeal shall stand dismissed automatically without reference to or order of default.
This is about 66.
And I think
Vikram
that the
Balaji.
appellant, my lord, is still waits for a notice, my lord, week's time, my lord.
4th April.
This is number 67.
Actually,
Ajay Kadkol T. 8 office objections with mint
The
evidence.
complainant, my lords. The writ appeal is not maintainable, my lords. The writ appeal that they have filed is not maintainable, my lords. I am for the complainant against which they have filed. Your lordship may kindly look at page 13, my lords. Just to evade from paying, my lords, they're doing everything possible. Your lordship may kindly, my lords, peruse page 15, page 13, my lords, of my complaint.
Complaint. That's for complaint.
And the complaint. ಅಲ್ಲ, writ appeal.
now ask CC.
No paging. Now she is open to contempt.
I am for the
So we appear for appellant in this matter, my lords. I seek for a short accommodation. Senior is dispensed because of his health issues. So I seek for a short accommodation to address on the maintainability matter.
one submission. Let them deposit some amount in the account. My lords, it's been 1 year since this order has passed by learned single judge. And your lordship may kindly see page.
Preferred appeal.
My lords,
that is not made.
with regards to monies, I just want to make one submission. Although I'm not aware of the entire thing that is available on records, I am not instructed on that matter at all. With regards to maintenance, my lord, there is joint loans and EMIs that has been paid only by us. There is no contribution from their end at all.
That is not even the crux of the matter, my lords. Page
My
13
lords,
is
if
the
we are
order
going to
by the
assess
learned
everything, it
judge,
should
my
be
lords.
assessed
They
everything,
have
my
to
lords.
pay
It
at
cannot
page
be in
13
part and
and
parcel.
14.
Will
Page
amount to
14.
injustice. My lords, I just seek for a short accommodation so that my
For
senior
what, my lords? They
validly
have to pay.
address
That is
the
all, my
issue.
lords.
It's just matter of 3 days, my lords, that's it. He will
My
address
lords,
the
it's
issue.
been a year, my lords.
Appeal is there. Monday, both.
My lords, Monday he is appearing in Supreme Court. Any day apart from Monday, my lords, please.
Tuesday, my lords.
On the day when your senior is not appearing.
Just one request, my lords. It subject to my lord's
Tell
convenience.
the date.
Huh?
Tell the date.
Day.
Tuesday, my lords.
Except Monday, any date. My lord's Wednesday would be convenient. He'll be traveling back, so then I don't want to come and make another excuse before
My lords,
my
every
lords.
time this is the submission, as your lordship is.
You also sometime go to the Supreme Court and ask.
Great.
But not far away, next week, yes. Yes.
Mr. Ravi Shankar has filed an application for impleading and for
staying my lord's order, my lord, whereby my lord permitted the government, my lord, to utilize 6 guntas of land. That's a, and he appears for the person who feels affected by my lord's order.
Which matter?
I'll not
You
take more
remember?
than, Lords, in a public interest litigation, certain
No,
stamp
which
duty.
listed to
The next
this-
matter, my
this
lord.
matter
The
is-
next matter. My lord,
68.
96 matter.
68.
No, writ petition is
the very next
disposed of.
matter. Lords, it's a disposed of matter, which is a public interest litigation matter. Lords, a property was identified for the purpose of putting up of a school and a primary health center. Lord, that was disposed of. Government made an application saying that there is a report of an engineer that the land is not suitable for putting up of the primary health center. Instead, they suggested one more property. This honorable court said, all right, you go and put up construction. But what they did not say, my lords, before this honorable court is, that's a property, my lords, which is the temple. It's a temple trust which is running that temple. And there are records from the past over 45, 50 years that this is the temple property. That is a matter which was, now what happens? We go before the KAT and say, this is an order, because we were not aware that this public interest litigation has taken place. They have made such a statement, we were not aware. When we go before the KAT and challenge the order, they make a statement saying that this is pursuant to the orders of this honorable court that we are doing this. Not that they said this and your lordships permitted. The statement there is that your lordships have directed them to do it in this survey number. Therefore, they are doing it. Now, in respect of this entire property where there is a temple, infrastructure of the temple, everything is in place. Now, in that 6 guntas, they wanted to utilize for
Small portion.
Lords.
No, it's for the, between government and him. So far as I am concerned.
We'll take up on 18th.
But one matter.
Lords, can I request, my lords, that let them not, because it's a temple and infrastructure, let them not do anything till your lordships takes up the matter. My private rights will be affected, my lords.
Without hearing, we know.
Can I request for a shorter date? Of course, I'm in your lordship's hands. Whatever date your lordship suggests, I'm before your lordships.
12th.
Very well.
Yes, one matter, not that. Paljiga Sangha matter. It was posted to seal number 78. 2 days ago, it was posted at 2:30. We sought an accommodation for today. It was
78.
seal number 78. Actually, 2 days ago, it was posted at 2:30 and then we requested for today.
It is for office objection.
It is complied, more or less. The related matter, connected matter is complied.
So
The
when
lordships had posted it for day before yesterday. Then we sought time for today.
So when
Friday,
shall-
my lord. Friday. Friday, 2:30.
is that urgent?
It's a little bit urgent, but Friday or Monday, 2:30.
Monday.
Monday.
With kind permission, serial number 74, my lord. 74, my lord, insofar as the third respondent is concerned, my lord. The other respondents are represented. The third respondent, my lord, since he died, my lord, a paper publication was taken before the single judge. But in spite of the paper publication, nobody has appeared. And therefore, my lord, the notice to third respondent may kindly be dispensed with, my lord. He died during the pendency before the writ petition.
We'll put up on 11th and we'll see.
75, if I'm not, 75 is a writ appeal of the state. 75.1 is my contempt petition. In spite of lapse of 2 years from the direction of the honorable single judge, that we are not absorbed into services and few of us are getting superannuated also. There's a delay of more than 300 days. Government has calculated as 255 days. Delay is not explained at all.
We'll take up.
Any early date, Manoj?
Get the date.